Hello and good morning. Hello. My name is Mark Patterson and I'm the chair of the Hawaii Correctional System Oversight Commission. And I was tasked by HCR 23 to chair this task force and the work that we're about to do in the next 9 months. So thank you all for being here. And before we begin this journey together, I'd like to take a moment of silence just to ground ourselves in the room that we are right now and to of course, remember the victims in Maui and everything that our state is trying to do to bring wellness and resiliency back to the community of Lahaina that we love so much. So we'll just have a moment of silence for the next 10 to 15 seconds. Thank you. Mahalo, mahalo kiakua, mahalo. As we move forward in our thought processes and the time that we're going to share together, let's start with our introductions. We'll go around this way so we can have a check off my list to make sure that everybody that was invited that's mentioned in the resolution is present.
Hello, everybody. My name is Kristen Johnson. I'm the Oversight Coordinator of the Hawaii Correctional System Oversight Commission.
Hi, I'm John Kinaga. I'm with the Public Defender's Office. I'm the Appellate Section Supervisor.
Aloha, my name is Ron Ibarra, retired judge from the Third Circuit, 28 years, and I'm in the commission now.
Mark Asham, State Legislature. I represent East Honolulu. I'm the Chair of Public Safety.
I'm Representative Greg Takayama, representing Pearlson.
Aloha, I'm Martha Ross. I am here to add in the victim perspective with 2 other folks, I think, that aren't here right now. One is on the Zoom.
Good morning, Gene DeMello. I'm on the parole board.
Fred Young, Chair, Parole Board.
Corey Ray Canton, Chair, or Acting Administrator of HBA.
No, he can.
You already know he's advisor to the
Steve Wong,
Andrew Martin, Maui Prosecutor. Adrian Daco, Attorney General's Office.
Good morning, Brenda Bauer-Smith, designee for Department of Health. I'm the Court Evaluation Branch Chief.
Erin Harbinson, Director of the Criminal Justice Research Institute.
Good morning, I'm Kevin Souza from the First Circuit Court.
Jennifer Casella from the Council of State Governments Justice Center.
And Carl Reynolds, Council of State Government Justice Center.
Thank you. Anybody else out there?
Ariel Reynolds, Criminal Justice Research Institute, and the Research Analyst under Dr. Harrington.
And on the Zoom, can you go ahead and introduce your folks else?
ALSU, Kauai Prosecutors.
Andrew Kennedy, private attorney on the Big Island in Kona.
Kelvin Walgen, Hawaii County Prosecutor.
Good morning, Brennan Siegel, a criminal defense attorney and former prosecutor.
Good morning, Sonoika Aihui from Women Helping Women in Maui County, and I'm here to provide the victim perspective.
Good morning, Kara Kampani with the Hawaii Correctional System Oversight Commission. I hope to be in person, but I'm not feeling well today, so glad to join online.
Hi, Richard Mizusa. I'm representing Senator Glenn Wakai today.
Miss Lindsay, are you there? Ulu Lindsay, Chair of the Office of Hawaiian Affairs. Thank you, everybody.
Sorry, I think I had my microphone off. Sorry. Good morning, everybody.
Good morning.
Good morning.
You can introduce yourself.
Yes, this is Hulu Lindsay, the chairperson for the Office of Hawaiian Affairs Board of Trustees.
Thank you.
Nice to be here with you this morning.
Thank you all on the internet. Thank you those who are here physically to be a part of this task force meeting today. We're so excited to be a part of this right now as we really look at the state and it's moving toward rehabilitative and therapeutic models. And if you look in the past several years of more than 5 years, some of the task force that we created in terms of looking at population control and re-entry that eventually formed the Hawaii Correctional System Oversight Commission. We look at the task force on trauma-informed care that eventually became the Office of Wellness and Resiliency. So now we have this task force here to look at the Paroling Authority and their sentencing or setting of minimum sentences. Where that leads us to is our journey, right? But we can see already that the state is moving to creating a better way of doing things in its systems. And so we want to focus our thoughts and mind on how we can improve, if need be, the way we do things. Yeah. With that being said, you know, just a few rules that we want to run this meeting with as much aloha as we can, and by statute. Okay. Also, we want to respect each other for our point of views. And as if you heard everybody here, we have a wide variety of individuals from the state agencies representing different perspectives. And we want to give everybody a comfortable and safe voice here at this table, and that everybody's voices matter in our discussions. So with that said, you know, let's not keep our conversations without interrupting speakers, and let everybody's thought be heard as we have our discussions. Simple housekeeping rules. We have bathrooms right out the front door. Kusuji folks need to use the bathrooms. We have some refreshments here that have been provided so that as we feed your mind, you have something to feed your stomach so that there's balance. We can't have meetings in Hawaii without eating. So, sorry, kind of for me more than you folks. So first discussion, real quick, we go around the room. There has been concern on whether or not we should have allow the public to be not participants, but at least to listen in on the task force during their meetings. Now, when we look at some of the previous task force across that I've already mentioned, I am aware, for example, of the trauma-informed care task force that the public was invited, but they did not participate in the meeting, but they were there to observe the conversations between the agencies and the community people that were on the task force. Task Force 85, population and the re-entry, was also another one that community was actually involved in those meetings. Yeah. And so we wanted to take this time to, before we made a decision, to have a understanding or go around the room and get a point of view. And what we're suggesting is just that they have a point of listening to the conversation. Now, the Hawaii Correctional System Oversight Commission has made a commitment for the community that on our agenda, on our monthly meeting, we will speak about HCR 23 and then give them an opportunity to respond to what we have to say. We have a tab on our website where testimonies will be posted. Yeah, information for you folks to look at as well. So you have a feel of what the community is saying. Last night, we did have a community meeting at the University of Hawaii, which we invited, and almost 50 members of the community came. We were very impressed at the participation. We had government employees, we had correctional officers, we had formerly justice involved individuals giving testimony, we had advocates for reform in the correctional system, and we had victims. Yeah, so it was a good discussion that we had last night, and an ability for those 50 members of the community to come and share with us their concerns as we move forward. So, as we continue this discussion, I'll start with the right. We can just go around concerns about the public, as I have just shared, being part of the meeting. Do you have any issue? Yeah.
My position would be that the public should be able to listen to the meetings but not participate. I think there are opportunities you guys can give the public to participate in other forms, but to kind of facilitate the discussion and the, just the meeting itself to move forward. I think it's easier if we're in these sessions, we just allow them to observe and not actually participate.
I agree with what has been said, except my hopefully definition of the public is the entire state. I come from a neighbor island. I know most of the meetings have occurred at Oahu, and I like to see the neighbor islands allowed to at least listen in.
No real concerns. The legislature is open to the public, so thank you. It's par for the course.
I'm not a member of the task force, so I'll reserve my comments.
Aloha, yeah, I was actually excited to hear that we might be able to have the public listen in. That would be excellent. I really did think that these had to be publicly noticed as well, so that is really important to me. And then it seems like for participation, it would be nice to have an ongoing link for testimony for people to submit. So it sounds like you may be doing that already, but it's great.
Yeah, I'm in agreement. I'm not opposed to listening in.
Yeah, I echo the same thing John has said. Listening in is fine. I think once the task force members have laid out their positions and the resources and documents and the laws and everything else, and there's been adequate discussion, then the public, if they're willing to provide additional testimony, that might be reserved for later. But for now, I think initially listening in and observing would be great.
Thank you, Frank. Concur.
I'm not a member of the task force, so
I think it makes great sense for and it was a really good meeting last night, but I think keeping it focused on minimum is going to be such a challenge for the chairs and the folks from the council of state governments, because people want to, fix the whole criminal justice system. That's not going to happen today.
Hi, Connie.
I'm not opposed to opening up for the public. Likewise, no objection. I just had a question in terms of the public being able to solicit testimony or provide testimony. You said that it was on a website. Is that for the Oversight Commission's page, or does the task force have its own?
The task force hasn't created something for itself. So because we were the Hawaii Correctional System Oversight Commission was in the resolution asked to be the chair, we just went ahead and created a tab on our website for that.
I was just thinking it might be easier or less confusing if the task force has its own page if people wanted to provide testimony. I don't know the logistics about that.
not opposed. Not opposed.
We're providing research support, but not officially member on it, so I'll just be neutral, whatever.
Thank you, Aaron.
I'm not opposed either, but I want to echo, what Judge Alm said about, I think that we really need to keep the conversation focused on minimum hearing, because I attended last night's meeting virtually as well. And as he made mention, people want to talk about a lot of things, but we got to keep the main thing.
For the clarification that the public listening in, does that mean
by Zoom exclusively, or
So,
would we have a room where it could be accommodated?
yeah, so that was one thing I was gonna say, because for me personally, I get really, really distracted by, people putting things in the chat. And so in our public meetings, so one thing that we could do, if people are concerned about like public comments or, the chat blowing up, is we can live stream on Facebook and YouTube. So that people can't actually log into the Zoom, you know, they can't like be in the meeting, but they can at least, you know, watch virtually on, social media or YouTube. So that might, it sounds like that might be a happy medium, maybe.
It's like the legislative hearings.
Yeah, yeah.
But I was actually wondering about physical presence in a space maybe different than this one. Whether that's a possibility or whether people are even thinking of that. Having the audience, having an audience for me, it's physically. I obviously.
Yeah, I personally, I would be opposed to having outsiders come in person. I sat on the HCR 85 task force and there was a lot of distractions. And sometimes the meetings took longer because chair didn't want to cut anybody off. So if we're going to stay focused on minimums, then I would say you can listen in, that's fine, you know, but to have it in person can be distracting and take away.
Yeah, and what we can do too, because we have like a public testimony piece on our website, but we can add that specifically for the task force, and then we can bring in like printed out copies if people submit anything, and that way task force members feel up to speed with what people are saying.
I don't see where, in the resolution, where we should take public comment. Am I missing something? Because nowhere in here does it say.
Yeah, we're not taking.
We don't-
we're not taking public comment.
So what about these recommendations coming from the public that you're talking about?
To the
So,
commission.
yeah,
No, but the resolution doesn't say that. It doesn't say that you
Well,
should.
this is a commission thing.
but it doesn't say that we can't either,
Yeah.
though. And I think that like when the community doesn't feel engaged or involved at all, like if they feel shut out, then typically what I've seen is like they'll try to tear down the process and make it seem like it's not valid, or that, you know, because they didn't have any opportunity to be involved.
Okay, I disagree. That's fine.
Are you disagreeing to public being involved in the meeting?
Right, because in the, again.
That's why you came in late, I just want to make you understand what everybody's talking about.
Okay. So, did I miss that part of the
It was
discussion?
just whether or not they could be a part of the meeting by just listening.
No, listening is fine.
Yeah.
What I'm saying is, I don't think it's appropriate that we accept any comments or recommendations from the public for the task force, because it doesn't state that in here. That's all I'm concerned about. Because I thought the discussion should be centered around minimum terms and amongst this group here, without outside interference.
It seems like what everybody said.
Yeah.
Okay, fair enough,
Yeah.
sorry.
So
Sorry, I was
no-
late too. Wait a minute, sorry, I was late.
No, no.
Apparently no garage around here. It takes a car that's taller than 6 feet. I had to go around, sorry.
Okay, thank you for that discussion, everybody.
All right.
I think we wanted to meet physically for this first meeting. I think my next discussion would be real quick is whether or not, are we okay to do Zoom? And make it easier for a lot of you who have busy schedules to do this from your offices? Or do we want to continue to do physical? Neighbor Islands, of course, are meeting, we're given the Zoom option right now.
Is this gonna be quarterly?
Mhm.
I think we should meet in person if it's gonna be quarterly. So much more engaged and.
Yeah, I agree. I mean, Neighbor Island, obviously, we got a lot of things going on Maui, but I'm here today. I mean, I think this is an important topic, and the discussion and what you get done in person is completely different than what you can do virtually. So I'd be in favor of having it in person.
I third the motion. It's like in-person hearings versus virtual hearings. We get a little bit more when we face the inmate and have a free flow of discussion.
In any opposition to that?
I have no opposition to meeting in person. I think meeting in person is great. My only ask, if it's possible, is that we move the date, or the day of the week, I should say, from a Tuesday, for a host of different reasons. The judiciary, we mostly pick juries on Monday and Tuesday. And so I realize this may be a selfish request on my part, but Mondays and Tuesdays are really sort of impractical for the judiciary to participate. And so if there's another day of the week that perhaps we could look at, I would make that request, but I don't want to impose my schedule on everyone else.
And at least 2 months in advance, you could hearing schedules.
Yes. Is there any particular day that works really well for people? And are we okay with the second week of the month still? Maybe we could do like the second Wednesday or Thursday.
Let me just throw out a date. Is November 15th okay for one final meeting in 2020?
So far, so good. If it's in the beginning of the month, we pose a lot of minimums and parole violations.
Is that a good date for you?
15th is okay.
Guys, have any concerns or
I
can,
That's the day before our commission meeting. This is really hard. We do the 8th.
can we look at the 8th? November 8th?
I'll probably have parole violation too on that day. And I usually like to be at PB hearings.
I mean, I'll make it work.
Okay. Okay, we're okay with November
15th was good.
And we'll send out the same calendar invite so everybody has it in their calendar.
So I believe that works for me as well. Apologies for not being able to come to this meeting as I had already a very stacked schedule. In terms of like hearing public testimony, I think that's really important that we do that. I think we need to have the audience, well, maybe not necessarily testimony, but just we need people to be able to see if there's anything on Maui, I think that we've learned, maybe Andrew, you can attest to that, but is that people need information, and when they don't have information, they're upset. And so having that transparency is really helpful for the public in general. Not necessarily that we'll take everything that they say with, and put it under a microscope or anything, but that they should just be aware and have that knowledge of what is happening. And yeah, that date works for me. So if you guys are setting it for the 8th, that's great for November.
It's the 15th.
15th.
15th, that also works for me.
Thank you. Anyone else online want to have a comment about the public or the next meeting date?
I'm okay with it.
I'm okay with the next meeting date, and I tend to agree with the public. Listening's probably a good idea, but kind of minimizing their participation in it is also probably necessary for keep the meetings moving and keeping some order.
You. Okay, hearing any more comments online? If not, we'll move forward. Thank you, everyone. We'll have a summary sent to everybody of the decisions that have just been made in terms of how we're going to move forward with the public. HCR 23, the resolution was pretty historical. And we invited individual responsible to come in and introduce himself and the purpose and the reason why. So, Representative Takayama, thank you for all your hard work. Floor is yours.
Oh, thank you very much, Mark. It's been an interest of mine, the public safety system as former chair. And I'm glad to support Chair Hashem as current chair. Thank you, first of all, to all of you for the months ahead of the time and in some cases, resources you'll be providing to this task force. There's many reasons for introducing a resolution that calls for a study or a task force. oftentimes it's because the author had something, a motive set in mind for the end result. I promise you that wasn't the case in this case. You know, I'm neither pro parole board or pro courts in terms of the system, but I do know that when Hawaii is the only state to do something, sometimes it's with a purpose. I mean, we're the only state to have a statewide education system. And it's been considered by the legislature and voters as well and supported. In this case, I don't think it's been thoroughly discussed, and I hope this resolution and the task force discussions provide a vehicle for doing so. And regardless of what the end result is, I am simply hoping for a frank, candid discussion among all of you. There are two things about this task force that are unusual. Number one, it's a large task force with 24 members. In the resolution that was adopted by the legislature, it was purposely so because as far as we're concerned, you members of the task force are the community. You each represent a certain point of view as victims or as members of the criminal justice system. And so it's our hope that, my hope at least, that you bring your experience and expertise, personal biases based on your personal knowledge and experience to the discussion in front of us. And so that's why I am hoping that whatever discussions you have, be as candid as possible. You know, the task force, secondly, is provided with a lot of time. Usually it's just a matter of months before your report is due. In this case, you have almost a year. And that was, again, purposely to give you the amount of time that I thought was needed for a thorough discussion of this issue. Finally, just, you know, remember that my office, as well as I'm sure Chair Hashem's, has a bookcase that's full of reports that have never been adopted by the legislature. And it's my hope that this report will be unusual. The fact that you have the chairs, Chair Hashem and Chair Wakai, as members of the working members of the task force, again, I think brings a lot more credibility to whatever results you produce. So with that, you know, best of luck to all of you. I'll be carefully monitoring your discussions and results and hope for the best. Thank you.
Thank you. Appreciate it. As we move forward on our agenda, I'm going to call upon the Oversight Coordinator for Hawaii Corrections Oversight Commission. Go ahead and introduce our guests.
All right, so the Oversight Commission has been really, really fortunate to have a few national partnerships, and the Council of State Government happens to be one of them. The Council of State Government, specifically the Justice Center, you know, reached out when they learned about this task force, and they said, like, what can we do to help? And we basically said, literally anything you can do to help. So I'm so honored and excited to introduce Carl and Jen from CSG. They'll talk obviously more about their organization and what they do, but we're really, really fortunate to have them with us today and throughout this process to help us learn and grow and figure out the best path forward for Hawaii. So thank you both so much for being here.
I'm going to give you the floor. And then we're going to came a long way. We'll honor you again. So you can go home with multiple lays from Hawaii.
I realized I was walking around last night with this thing on. It's like, over. Thank you so much.
You want to introduce yourself and all of the your background?
Sure. I'm Carl Reynolds, Senior Legal and Policy Advisor with the CSG Justice Center. I'm retired from state government in Texas. I worked in the legislature way back in the late 80s. I was the general counsel for our corrections agency for many years. And I was what's called the state court administrator, Rodney's role here in Hawaii. Up until 2012, I retired from the state, came to work for the Justice Center 2 weeks later, and I've been doing this kind of work pretty much for the last 11 years.
Jennifer Casella, Deputy Program Director at the Council of State Governments Justice Center. I have been with the Justice Center for about 8 years, working on state level policy, assessing state systems and taking a look at kind of where they are in comparison to best practices. And if my area of expertise is around community supervision, Department of Corrections programming, parole board decision-making and reentry. Prior to the Justice Center, I worked for about 15 years out of the state of Ohio in community corrections. So happy to be with y'all today. We do have one other member of our team, Sepper Reynolds Tanner, who is a policy analyst. So if you see her name around anywhere, just know she's with us. I'm based out of the Seattle area in Washington State. I think so. You said you Carlton, Texas.
I'm still in Austin, Texas. Living the dream.
So we're honored to be here today. So I wanted to walk you through a little bit about the Council of State Governments Justice Center and assistance that we can provide to the task force, and also taking a look at kind of laying the foundation around kind of the context in Hawaii so that we're all working off of the same framework. I am definitely not an expert in the Hawaii system. I would defer to all of you as the experts in the Hawaii system. So I invite you kind of after I talk about the Hawaii context for you to add any additional information and insights into that, but just felt like it would be a good opportunity to have us all working from the same kind of baseline information and context. Carl's going to talk a little bit today about sentencing systems. One of the task force obligations is to take a look at where Hawaii is in comparison to other states in the US. So Carl has detailed out 11 different systems in the US and how they operate to kind of walk you through and show you some different examples of how other states set minimum and maximum terms of maximum terms of incarceration. And then talking about kind of next steps and kind of the best ways for the task force to proceed and getting your input and insights on how we can be the most assistant to the task force in terms of things to do or prepare for the next task force meeting to be able to provide you with the information that would be most beneficial for you. So the Council of State Governments Justice Center, we're a national nonprofit, nonpartisan organization, a membership organization, and the Justice Center is the criminal justice arm of the Council of State Governments. And it's really designed to provide policy and research guidance to all 3 branches of government. And the goals of our work are really to help break the cycle of incarceration, looking at improving health, opportunity, and equity for people involved in the criminal justice system or who come in contact with the criminal justice system. So we do a lot of behavioral health work as well within the Justice Center. And then using data, whether it be existing research or doing our own statistical analysis to be able to take a look at systems and help develop solutions to improve public safety and justice. Our work really centers around bringing people together in consensus building. So we're, as a nonpartisan organization, we're not coming from an advocacy role in terms of advocating for a specific kind of policy or direction. It's really about finding out what the needs are and what the issues are within the locations that we're working to develop solutions that are tailored to those locations and doing it in a consensus-driven way to move the field forward and bring about policy change. We're also very focused on equity and inclusion. I know this has been a topic around Native Hawaiians being disproportionately represented within the criminal justice system. So identifying kind of equity and inclusion opportunities in the work that we do is also highly important to us as well. So our work here with the task force is made possible through funding with the Bureau of Justice Assistance. In 2012, I know some of the members here were involved in Justice Reinvestment Initiative here in Hawaii, but through going through that Justice Reinvestment Initiative, that has allowed Hawaii the opportunity for some additional funded technical assistance, which is what we're tapping into in order to assist the task force. So it's out of the same kind of funding arena as Justice Reinvestment through BJA, but it's kind of a special project that they're allowing us to do under that funding that we have allocated through them. So it is free of charge to Hawaii for us to provide the technical assistance to the task force. So we're really happy to be able to engage with the task force and provide support. The Justice Center has worked with approximately 33 states to look at correction spending and to drive public safety and increase public safety in the states. We're currently working in 4 states in terms of our justice reinvestment approach. And we have a history of doing work in Hawaii. So in 2012, we had the justice reinvestment, followed by some victim restitution matters that we worked with the victim compensation program around. And then in 2022, so this past December, CSG held a national conference here in Hawaii in December, which I heard was very well attended and well received. I'm not sure why, but lots of people were excited to come to the islands for the CSG National Conference in December. So, as the representative had shared, the task force is large, 22 members. Is definitely a large task force in terms of consensus building, but I think it's amazing with the representation that you have to bring diverse perspectives together around the topic of minimum sentencing, to be able to take a look at things that are working well, and if there's opportunities to make change, what those need to look like within Hawaii. Which brings us to the HCR 23 mandate. So there's really kind of 3 main things that stand out in terms of the HCR 23 mandate, and looking at kind of what are the different models of setting minimum sentences across the US, which we're going to get into today. Also examining and comparing the minimum sentences issued by HPA and the courts to determine if there are significant differences. So our interpretation is this is looking at some of the mandatory minimums that the judiciary sets in comparison with the HPA, and then recommending whether the administration of justice would be better served by removing the responsibility of minimum sentences from HPA, and what that might look like. And so with the task force, there are some deadlines, which I'll defer to Kristen on the exact, but I know there's a date in August of 2024 around legislative recommendations. I believe it's August 1st. August 1st for the task force to issue any legislative recommendations, and then October 21st. October 21st. Thank you. For the full report to be submitted to the legislature. So it definitely gives a long runway, but also looking at quarterly meetings, that only leaves around 5-ish meetings, which when you think of that in the scope of things isn't really a lot of time either. So looking at kind of the best trajectory to figure out how to get the information that you as task force members want to see and need to see in order to make your determinations and recommendations. And Carl and I are really here to support you and what would be most helpful and valuable for you in terms of, if there's observations or information gathering, stakeholder engagement with people outside of the task force, as well as task force members, as well as any data analysis, things like that are all things that we would be able to assist the task force with. So I want to get into the Hawaii context and how the system is designed and set up in Hawaii, just so that we're all working off of that same baseline. And as y'all are aware, I say y'all, I'm Midwesterner coming out, or we probably not a common term, but born and raised in Ohio, you get a little Midwesterner with me as well. But in Hawaii, the correctional population has been declining over the past several years, which we see that in a lot of other state systems as well as a result of COVID with those population reductions. But even with that reduction, there's still over 800 individuals who are on the mainland serving their sentence. And so, we kind of see that still as kind of some pressure points within the system, but there's still folks serving time over in the mainland. And also recognizing just the pressures on the Department of Public Safety, HPA, and the legislature around facilities, conditions within facilities, the building of a new jail, programming and treatment. And so we see all of that kind of pressure. I know we've seen some of the news articles and the civil beat that have come out. Yeah. Steve?
Yeah, I know the numbers are going down, but I wonder how much of that is because the courts were closed because of COVID for a period of time. Right. Judges have said they've got filing cabinets full of revocations.
Yep.
People are wanted on warrants. So I hope it stays down there, but the courts are doing trials now and going through it, and maybe Judge Souza has more insight into that than I do, but we know we have a huge backlog of murder cases to do. We have, I don't know what it was, when we looked a year ago, it was 129 murder cases to go to trial, and those will likely go to trial. So anyway.
Yeah, we are definitely seeing in a lot of systems across the US, you have the dip in the populations with COVID, and we're starting to see them trending back up. Some don't look like they're gonna trend up to previous levels, but other states, they do look like they're gonna go past previous levels or exceed previous levels. So, I don't know the full context of the backlogs within the courts, but that's definitely something that we hear in other states as well. Backlogs in courts, cases waiting to be filed with prosecutor's office, trial backups that are definitely going to impact those correctional numbers as well. So, it wouldn't be a total surprise seeing that go back up, because we're seeing that right now in a lot of other states as well. So just kind of recognizing kind of those pressures on the system and the system actors. And those of you in this room, I think, even though that population was going down, it doesn't eliminate kind of the pressure and the necessity to take a look at the system. When taking a look at the landscape in Hawaii, one of the things that we took a look at was how much the state is spending on corrections in Hawaii. And you can see in comparison to some of the other kind of far western states that Hawaii is doing more with less. And I don't know if that resonates with some of you who are in the room, but when you take a look at correctional costs in comparison to the general fund and what percentage of the general fund is allocated to corrections, you see some states are double what you are here in Hawaii. And so you're definitely doing a lot with less than some other places. And so I just want to recognize kind of that.
Or we have old antiquated facilities that are not getting funded.
Yeah.
I think that's more of the issue.
Yeah.
Trust me.
When we take a look at the system generally, the three branches of government, there's the shared public safety goal that all three branches of government have when it comes to sentencing policy in particular, between the legislative, judicial, and executive branch. However, each branch also has kind of its own additional goals, with the legislature typically looking at proportionality and consistency in sentencing through statutes and what they're doing statutorily in sentencing. You see the judicial branch really ensuring that individualized justice and taking a look at the individual level with people who are in the system and sentencing. And then the executive branch with the Department of Corrections and the Paroling Authority looking at incentivizing and sanctioning behavior, release and readiness, and trying to find that sweet spot, an intersection of kind of risk to public safety and readiness for release, and when is the best time to release someone back into the community that's going to enhance public safety the most. And so each branch of government kind of has their own goals on kind of how they work within sentencing, but it all ultimately comes down to that public safety piece. And when you take a look in Hawaii, I think one of the items that really stands out in terms of sentencing is that in Hawaii, the judicial role in sentencing is actually minimized compared to what you might see in some other locations that Carl is going to walk through, while the paroling authority is maximized. And so, Hawaii statute establishes the offenses, sentencing options, the maximum sentence length by felony class, and allows the paroling authority to set the minimum terms. But the judiciary is really just looking and determining the offenses committed, and kind of what those basic sentencing options are, right? If someone's going to probation versus prison, and then if they are going to prison, what that maximum is, which is really laid out in statute, right? So there's kind of that minimized judicial role, with the executive branch having a larger role in terms of those standards for minimum, setting the minimum terms, as well as the parole, release, and revocation. And then you also, just noting, which we'll get into a little bit coming up, is that there's no good time authority within DOC as well, which you see in some other systems. Yeah.
How is it that you weigh that the executive branch has a larger role in the sentencing than judiciary? Or did I mishear that?
No. Yeah, because a lot of, once the decision is made to send someone to prison, the maximum is kind of really laid out in statute.
Right.
And so in other systems, kind of there's a little bit more discretion in terms of the judiciary on length of time incarcerated, as well as they're setting that minimum range. So when you take a look at it from just a decision-making standpoint, there's more kind of authority and autonomy with the paroling authority than what you see kind of with the judiciary when it comes to prison sentences.
I guess we'll have further discussion on that.
Yeah, I think Carl's going to get into that a little bit when he kind of compares and contrasts some of the different states and how certain terms are set up in different states, which I think will help kind of clarify, but definitely want to hear some of your thoughts and opinions too. So the Model Penal Code was put out by the American Law Institute in, I believe it's 1962. Why is it not? Oh, it's laggy. That's all right. So you see in the 1970s, Hawaii started utilizing the model penal code that was put out as a way to help inform some of the structure and substance of criminal codes. There's no state that I'm aware of, right, Carl, that kind of fully uses everything in the model penal code in terms of their statute and how things are set up, but I'll let you talk a little more, Carl.
Well, in particular, I'm going to say a little bit towards the end of this presentation about a new version of the model penal code that just came out. It's just about sentencing. It's a fantastic resource. And no state is doing their work as depicted by the model penal code sentencing. I'm not sure. I think a lot of states have a penal code that looks a lot like this old 1960 document is what I learned back in Texas and so forth. But the sentencing stuff itself has been kind of superseded by this new report, and I'll say more about that in a few minutes.
So in 1965 is when Hawaii really ended the judicially imposed minimum sentences and switched that to the paroling authority. And so the philosophy behind that switch was to increase consistency. So, having the smaller membership of the paroling authority, there's less people making the decisions with the goal of improving consistency in that decision making for the minimum terms versus the number of judges that are spread across Hawaii making the determinations on that minimum sentencing. And so, there's still in Hawaii that kind of true indeterminate sentencing. The court's discretion, as I talked earlier, is limited to choosing between that imprisonment and probation, and then the paroling authority is making that release determination as well as the minimum term. So there are discussions around, degrees of indeterminacy within state systems, and kind of when we're looking at indeterminacy, we're really looking at kind of the amount of time a person is parole eligible, right? And the ability to predict how long a person is going to be spending within an institution. And so the more time between the earliest parole eligibility and release, the greater degree of indeterminacy there is in the sentence. So, if someone is sentenced for 10 years and they're parole eligible at 2 years, you have that kind of between that 2 and 10 years, that would be that kind of high degree of indeterminacy. Some states have much shorter parole eligible windows that might be a few months to a few years, right? There's different degrees of indeterminacy where people are parole eligible before they max out of a system. And so Hawaii has, in comparison to other states, has a high degree of indeterminacy in their system. So Carl's going to walk through some differences between determinate systems and indeterminate systems. But just noting that kind of with Hawaii's system, there's kind of no framework for shared discretion or kind of checks and balances that you might see in some other systems in terms of, the ability to kind of appeal minimum terms and how some of those sentences are set and adhered to in Hawaii. The board does have a lot of discretion to reconsider and change minimum terms, which is also a unique to Hawaii's system. So you don't always see that in other systems where the minimum can be revisited. So walking through a little bit about how Hawaii establishes minimums and maximums, the maximum sentences are done by felony class. So you can see the mandatory statutory maximum based on felony class. So class C is the lowest level with a maximum of 5 years, and that increases with class B and class A. So the seriousness of the offense are increasing with each of those class levels up to first degree and second degree murder.
But you know, there are some class C that's less than 5 years. The statute was passed, what, like 2 years ago? That allowed the courts, yeah. That allowed-
For drug cases.
For drug
Very
cases.
few and only
Yeah.
limited drug cases.
Okay.
Yeah, otherwise we don't have discretion on that.
And with the HPA, they utilize guidelines that were originally established in 1989, updated with the current HPA chair, and for setting the minimum terms. And so this really kind of sets out 3 levels of severity that HPA is looking at to determine what the minimum sentence should be. And so there's criteria that they look at. There's 7 main areas of focus. Originally, it was that the first 3 areas, the nature of offense, degree of injury or loss, and criminal history. Under Chair 2, it has been increased to those 7 main areas of focus. And they're really identifying kind of, if you think of it in terms of kind of a general kind of typical offense, that would what you would see in level 2. If there's mitigating circumstances, that would dictate a lower term in level 1. If there's aggravating circumstances, that would dictate a higher level minimum with the aggravated. Thank you.
Yeah, it wasn't me who created the 7 levels. It was there in place forever and a day, I think. But Robina Institute and others only identified 3 primary areas, being nature of offense, degree of injury, and criminal history. But all the other criteria were there beforehand, well before me. So I don't want to take credit for that. Good or bad.
Okay.
The 3 levels are set out in the 1989 guidelines that are on the HPA website. That's what this was originally based on.
Yeah.
It only came to me later to us that there had been some adjustment to the guidelines. It's a separate document.
But I think the GRI
Right.
made that recommendation, and that was the benefit of the state government and their recommendation. So one of them was to outline the minimum terms, which, to my knowledge, came up with the additional criteria, and that was incorporated, utilized, and the discretion for the years within each level is what gave the board that discretion. But it was there well before me.
Okay.
I don't want to take credit for that.
Yeah. We will make adjustments. There we go. So this is kind of the breakdown of those levels, and where you see in terms of the year range for each of those levels. And so, for example, a Class A felony, the maximum term is 20 years. If a person is identified as level 1, the minimum term is set between 2 to 5 years. If they're a level 2, the minimum term is set between 5 to 10 years. And if they're a level 3, the minimum term is set between 10 and 20 years. And what we did on the right-hand side is really take a look at what percentage of their sentence they would be serving if they serve the minimum in each of those levels. So going with the Class A example, if they serve 2 years of that Class A for the level 1 minimum, that would be 10% of their sentence. Versus level 2 would be 5 years, 25% of their sentence versus 50. So you can see as you go down, the less severe offenses, Class C, they're actually serving a greater portion of their sentence than a Class A. So you see some of those percentages increasing as the severity decreases. So this is just depicting that Hawaii sentencing release system design. So this is an example with Class B felonies. Level 1, they would serve 1.5 to 3 years in their sentence if they were found in the level 1 category. which would start at 15% of their sentence. And once they hit that minimum term, then that's when they become release eligible, parole release eligible. And the Hawaii Paroling Authority is starting to then have those parole release hearings for an individual. And when they're released on parole, they could serve on supervision up to their maximum term on supervision unless they're released early from supervision by the paroling authority. And kind of how that compares a little bit in other systems and kind of other typical systems that we see. The minimums are set out a lot of times in statute or through certain guidelines. And once they serve that minimum, they're release eligible. But a lot of systems kind of have some varying rules that can kind of shift that minimum or maximum term for an individual. So there might be some good time credits or some earned time credits, which will actually shift that maximum sentence down, or it might shift the minimum parole eligibility down to allow a person to be released earlier or have their maximum end date a little bit earlier. And so in Hawaii, you don't have that kind of flexibility as much to kind of shift, especially the maximum term down in terms of the good time or earned time credits that you might see in some other systems. So I know Hawaii has the ability to change the minimum through a process, but you don't have some of that same kind of flexibility that you might see in some other systems where you can change the maximum. I'll let Carl add in if there's some items that you want to have. You're gonna save it all.
So just one point to note, HPA approves about 19% of the ROM reduction in minimum applications that come through. So that is the reduction of the sentences, not across the board. Honestly, I would prefer that system, and let me tell you why. Because HPA looks individually at the application, and they make sure that, because the static things don't change, the nature of the crime, the degree of injury and loss to the person's criminal history. So what HPA does, when they look at the reduction in minimum application, they look to see what has the individual done to mitigate those static. And so it's not just someone who sits around and waits for the program. It's somebody who's doing other programs while on the wait list, somebody who's on the work line, someone who has positive work evaluation reports, who's making an effort to pay the restitution, who has a support system in the community. All those things go to the application that the HPA looks at. And so I think that's a much more efficient system, because you're really granting the application for those that clearly deserve it and that went above and beyond, not just sitting around getting cut time just because they're doing what they're supposed to and staying out of trouble. Okay.
Let me add on to that. That HPA by law and throughout history, HPA can only reduce those minimums that it sets by its own order. So if it's a court imposed mandatory minimum, HPA can't touch it. We cannot go below. So if the courts were to give a 7 out of 10, then we can't go below a 7 out of 10, irregardless of how well the inmate performs or has done programs or anything else. Same thing with a 3 out of 5 or 4 out of 5.
Is it the case that the HPA has the authority to impose a higher minimum than
we can?
And I have been unable to trace how that is the case. I don't see it in statute. I haven't been able to find it in case law, and that may be the problem. But I don't understand how that's the rule when there's no evidence that it was.
So maybe I can speak to that. So first of all, courts aren't imposing mandatory minimums unless they're set by statute.
Right.
I'm not putting my finger in the air and looking at someone and saying you should serve this amount of time. If I'm imposing a mandatory minimum, and there are only 4 situations where I can impose a mandatory minimum. That's repeat offender, that's the nature of the victim, that's a gun involved offense, and that's if it's prescribed by statute, for example, habitual property harm. Okay, so I'm setting it based on the statute. Now, I think it's under HR 706, 606.5. What the law says is I can reduce that mandatory minimum that's prescribed by statute if I can make findings of what they call strong mitigating circumstances. And in certain cases, I can and I do, but in most cases I don't, because I can't make those findings of strong mitigating circumstances. So that's where you find it in statute. But I just want to be clear, when we're talking about courts imposing a mandatory minimum, all we're doing is reflecting what's in the statute.
Exactly.
And I found that. What I don't see is where it says that regardless of what the judge did, the HPA can change it upward. That's where I haven't been able to find.
There is, it's in the note section of
There
the
is,
statute. It
where
said,
the
go ahead.
HPA can impose a minimum, its own minimum.
Right.
Regardless of what the court said, so long as we don't go below that statutory minimum.
And that's also in that statute, is that what?
Yeah, I think it's 350, 365.
Thank you.
And I just want to echo what Tommy and Fred have said. You know, I think when we set out to do our work here, it's very important to focus, as Judge said, about what it is that we're doing. Because, you know, I think we want to talk about who's going to set the initial minimum sentence. That's what the task force is requiring us to do. But if we're talking about reductions in minimum sentence, as Tommy points out, you know, the Department of Public Safety is in a far better position than the courts to make a determination as to whether a reduction in sentence is appropriate or not. Why? Because if you're asking me as a judge to revisit all of the factors I already considered in sentencing 2, 3, 4 years after the fact, I don't know how relevant they are anymore. HPA is in a better position, particularly, you know, the folks who are running the program. You know, when you talk about a reduction in sentencing, what's that going to be based on? That's going to be based, as Tommy said, on what this individual has done since they've been sentenced, not what they did prior to being sentenced. That determination's already been made.
Well, I'd like to echo a little bit. It's a little slightly different situation, but a number of months ago, I made a policy change in our office that tells the deputies you have to, you know, send a letter or participate in minimum hearings, but we will no longer participate in parole hearings because we don't have the information. As Judge Souza said, we don't know how the guy's doing inside. We don't know about misconducts. We don't know about attitude, all that. And essentially our deputies should be going in there and re-arguing the minimum, saying it should have been longer. And that should, you know, that has already been set. So we don't have that kind of information, but that's going to be an interesting point of discussion, you know, to whether you bifurcate that or not. I agree. So.
I think this is all super helpful context I know for me. You know, is there additional kind of context or information? I think, you know, kind of the goal of this is just to kind of set the foundation so that we're all working off the same working knowledge of how the system currently operates. You know, I know I'm not coming in with an agenda of the system is good or it's not good or it needs changed or doesn't need change. It's just that foundational knowledge, and didn't know if there is additional kind of context or information that any of you have that would be helpful to share. You know, I appreciate the chairman and Director Johnson sharing kind of their insights, as well as Judge Souza. If there's kind of additional information around that minimum term, you know, in the sentencing policy in Hawaii, that would be helpful to share.
Yeah, let me just add one thing regarding the matrix for setting a minimum. We could set, there is an area where we can reduce what's prescribed or identified as within the years per level. For example, if for the Attorney Generals, it's defensible if we gave the individual a level 3 nature of offense, and you know, we're looking at, let's say, a 20-year term. But because of the situation, when you review the PSI or police reports and any witness accounts, that there was a diminished level of responsibility, whether it's mental health, whether they're deranged or anything else, the board can go outside of that number using its discretion on the individual case to give them a 2 out of 20, which is almost unheard of, but it has that type of discretion, and we do utilize it, especially in certain cases where there's mental impairment. Yeah. So it's a broad range of discretion for the board, but it is in there.
So the board just has to make sure it's accompanied by a written justification on the minimum notice, whether it's up or down, and the board's pretty good about spelling out exactly why it made that determination.
I'm about ready to jump into my part, but I really want to hear, I'm intrigued by your comment earlier, Chairman, about your disagreement with the idea that your system is tilted towards authority at the parole end and away from the judicial system. To me, that's obvious, that's a feature of your system. So I'm intrigued by what I gather is you're questioning that assertion.
Well, let me make my position very clear. I intended to come in here as very neutral. I mean, if the Paroling Authority doesn't do minimums, that's great. We save on paper and staff and time, because minimums are the hardest things to do as far as hearing. Yeah. And hopefully you get all the proper information, documentation, and evidence, as Mr. Briner can attest to, when we do these type of hearings. But, there's different factors in determining minimum, and it's a broad range, and the board does have a whole lot of discretion, as well as when we set a minimum, we also let the inmate know that if you behave, you can apply for a reduction of minimum. In other states, they may not have that opportunity. Once it's set, or like in Missouri, you have a maximum term, the parole board may not hear your case until 4 months outside of their max, which is kind of like, wow, But there's so many things that HPA looks at, and that's why I appreciate having this forum, so that it's all out on the table and all parties are fully aware of what minimums take. And of course, are well aware of, their side with prosecutors and public defenders and defense attorneys, but they're only partial to their position, and we accept that. And, we can be very argumentative and confrontational in hearings, but when it's said and done, we all know our positions, and we're all good. But it is trying to be fair, and people don't understand fairness sometimes, and we try to be just, but in accordance with the law. But it's a fine line for board members when they hear cases. I don't know if that completely answers your question, Tom.
Well, I really appreciate everybody's participation and the input you're giving us. That's terrific. And
Miles, you have no one to say?
Very brief comment. Thank you. Fortunately, we have Steve here as well as Kevin. They have experienced what it is to sentence someone. Certainly, Steve was on the bench. Judge Susan's presently on the bench. I would submit that most defense attorneys would prefer to have someone sentenced to a term by the judge who has participated in the entire process, is familiar with all the arguments and all the issues that arose, as opposed to just looking at a closing report that generally what the parole board gets. And given the number of cases they have to appear in a typical day, we're doing the minimums, 2 dozen people stacking up, it becomes a pressure cooker situation for the board to determine what's fair and what's appropriate, as opposed to a judge who's had a chance to deal with all the facts of the case over many months, if not years, until the cases come to fruition. It's settled, whether by trial or agreement. It's fair to say that I would prefer a judge who's familiar with every issue and nuance of the case, making that determination. Yes, I have appeared before the parole board. I think all of us live in the system now. I've practicing 30+ years. I've seen Steve through all his iterations. I would submit that sitting before a judge that's heard both the prosecution side and the defense side, they've heard all the witnesses, And as a benefit of Andrew here, who's now the chief prosecutor, we've done cases together. I would say that he and I know more about a case that we did together some years ago than remotely the parole board would. Through every effort that they have, the fact is we know the details and the nuances. They could probably fashion or go to a judge and ask the judge to fashion an initial sentence as opposed to a massive open term. So I understand the parole board and position, Tommy, and Kevin, again, wore many hats. You've been on both sides of the equation. Now you're running BPS. And you see this dysfunction. So, for example, there's an open issue here that we haven't discussed that's collected in the presentation. Sex offenders. It's a growing population that we have. And they present a set of problems unique to sex offenders that ends up causing a great disequilibrium in the process. For example, the parole board would sentence someone to an open term, or excuse me, to a set term, but they have to do sex offender treatment in the process. They can't get there if they're sent up to the main one, because that's not provided, or the Department of Public Safety controls furlough, correct? And yet, time and time again, the parole board would recommend furlough, and that person remains in the system for years and years and years, despite, we can think of many cases I can identify today, choose to. But those are problems that can be resolved if we give the power back to the judiciary to make that initial determination with a fixed term. And then you see how people perform in the system. And yes, then the paroling authority, and I agree, they would know more than the judges do about how their performance is in the system. So, yes, Russ.
Thank you, Martha.
And I want to give the opportunity, I know we have people joining via Zoom, if there's anybody who is online that wanted to add to the discussion. Hey, George, do they have the ability to just come off mute and speak up? Okay. I'll just give the.
And my comments reflect the Hawaii Association of Criminal Defense Lawyers or often the individuals to the neighbor islands.
Didn't know where we were at. Timelines. Okay.
Yeah.
Do you want to do a break or do you want to?
Do people want a break? 10 minutes? Okay, 10-minute break. We'll reconvene at 10:30. Please eat the food. There's so much food. Eat food. And coffee.
Thanks to me, Tommy, for not Pam speak so much about you, Martha. I think we met long ago at some OHA hearing, said you were.
So what are you doing in the community?
Not as good. So right now, I'm actually helping with a program that was home share. We're trying to create that.
I think that we spend less money
Create
than
that not vacation, affordable housing, seniors. But I mean, I still. Yep.
Because the official.
She's in the plane, that's why she's not here.
Oh, there she.
That's the problem. She couldn't even be on Zoom because.
That's right, that's what,
Yeah.
We had a long conversation. I like Pam, she talks the talk and walk the walk.
Yeah, it's not good meeting, but I just wanted to say hi, and I didn't know if I handed one of these to you, but yeah, we'll send it out, but if you just put together a summary of information. Thanks. So I thought it kind of inspired me actually, like getting some listeners from the task force.
Oh, yeah, that's what we are calling you on.
Yeah. So that's why we thought it'll help with the report, and of course, we're coordinating for them to do as much as we can.
Everything else very well.
Yeah, we're super excited. We're about to exit the contract. We're about to start the development of the HR database. So we are really aiming to have something going It's green that we can actually plug with you and.
Yeah, and also the initial email that I'm gonna
Demo, so that's what they like. Because, you know, everyone's eager to what the stepwise build it, we thought it was hard to conceptualize, and I think, you know, what are metrics? So we thought we get a few things out there, and then we can get feedback to make sure we're doing what we can, make it informative, accessible for the legislature.
all of the other.
Yeah, I think I'm so excited, like all this planning and. Yeah, yeah. Yeah, and all, I know, especially in the fall, there's quite a people, you know, it's like, I know people are kind of. Check it out. Yeah. All right.
Thanks,
Probably have one radio.
There's just like such a long setting. But then like, you know, a lot of them.
Right, but it's a law.
Like.
Yeah, I wanted to know what we can do.
And then we got added, but we have a meeting with, So we have back meetings, 1, 4.
I think this is going to be
I go far, I just see the word.
Or
Yeah.
Good morning. How are you?
Good.
It's good. To get started.
I learned a lot.
Yeah.
Welcome back. Turn the mic over, the floor over to Carl at this time. Thank you, Carl.
Thank you. First of all, I just wanted to say, really feel lucky and privileged to get to do this work in general. To be in Hawaii this week in particular and to work with this group. It really is a privilege that we at the Justice Center enjoy. I never want to launch into something like this without acknowledging that. I really feel very lucky to get to do the work that I get to do. But jumping into this, I wanted to go back to the slide that Jen showed us earlier. This is the high level summary of what HCR 23 asks of this task force. And the point of this next section is to at least scratch the surface, if not go a little deeper on looking at some other state systems, other state models, how they do it, how they set minimums, et cetera, in a number of other states, and kind of pick out some examples, looking at a variety of different systems. While I'm on the slide, though, I want to just point out number one on here. To the extent that this group either doesn't reach any kind of recommendation for change in the fundamental character of your system, there is this other charge to really look at the way that the HPA works now and the opportunity to make some recommendations about keeping the authority with the HPA, but also making recommendations about how that actually works. So I just want to flag that as something else that we certainly don't want to overlook and want to have an opportunity to explore. So there are two kind of basic choices that states have in devising a sentencing system. And that's what this 4-part typology depicts. On the left side in the dark blue, SGL means sentencing guidelines. So some states have sentencing guidelines in that top row, and lots of states do not have sentencing guidelines, including Hawaii, including Texas, where I'm from, and lots of other states. So that's that basic demarcation. I'm going to say more about what that means in just a second. The other big choice is the one that's more familiar to this group, the choice between a determinate system and an indeterminate system. And as Jen said, it's a sort of a false dichotomy. It's a spectrum, it's a continuum of indeterminacy or determinacy. But the basic idea is that in a determinate system, when someone gets a prison sentence, everybody in the room pretty much knows how long they're going to do. And in an indeterminate system, nobody in the room really knows how much time someone's going to do. And you have, a shining example of a very indeterminate system here in Hawaii. And that's the more normal model. As you can see, there's a lot more states on the right side of this chart than the left side. A number of states did away with parole back in the 70s and 80s. And I'm going to mention a couple of those states. And as a general matter, an indeterminate state is a state with parole, with a parole board, a paroling authority that has some control over the length of time that people are going to serve once they get incarcerated. So on that last slide, there were 11 states were bolded. This is just focusing you, and just to give you a sense, on a map, I like maps, of the states that I'm going to mention to you in the next few minutes. And just lifting them up out of that chart to show you where they sort of fit on this typology of different systems. And so the point of this isn't I'm not going to end up saying North Carolina is the way to go or anything else like that. It's really just to lift up some examples for you to think about it. My assumption is that folks here mostly have worked in Hawaii, and this is the system that you know. And I've had the opportunity to work in some other states and study some other states. So I'm just trying to tell you some things that we've learned and that I've learned about the way this kind of stuff works in other states. Some similarities to Hawaii's system, and even some things that really are not working well in at least a couple of other states, just to kind of point those out as negative examples, if you will. So what do we mean by sentencing guidelines? I know you don't have that, and I doubt that there's a fever of interest in sentencing guidelines here in Hawaii. But I think it's a really important feature of the system. It's certainly important for this group to understand what that means when we just rattle off that term. So these 4 bullets are my attempt to just boil it down into what guideline states really look like. What that means is that the state has done a more elaborate job of ranking offense seriousness than the 3 levels in Hawaii or the 3 levels in Texas. States that have this simple old model penal code approach that's 1st degree, 2nd degree, 3rd degree with big long ranges. In guideline states, the state has sat down, gone through the penal code and done more of a nuanced ranking of offenses, sometimes 10, sometimes 16, but a much more of a ladder of offense seriousness. And that's typically depicted on one side of a grid like this image here. Similarly, the state has done an exercise of thinking about criminal history and usually coming up with like a scoring system for counting people's criminal history. How many prior misdemeanors, how many prior felonies, how many prior violent felonies, coming up with some kind of validated scoring system that ranks people's criminal history. And so what you end up with is a grid, a 2-part, one axis with offense seriousness and one axis with criminal history seriousness. And within that grid, typically, you'll see, you can't see it on this slide, but within each little box on the grid, each cell, there will be a sentence range, and it's much narrower than the overall range, the 2 to 10 or 2 to 20 in Texas. There's a much tighter range that's deemed to be the norm for people with that level of offense seriousness and that level of criminal history. So that's kind of the hallmark of a sentencing guideline system. You're adding in a layer of detail beneath the overall penal code punishment structure. And yes, Matt.
When we had the structuring sentencing, is that closer to the sentencing guidelines? So they're using other states that have it this way. Are they modeling it on the USSGs?
No state has used a system like the US system. And criminal defense lawyers are the ones that know about the US system. I have never been forced to learn about the US sentencing guideline system, so I don't know much about it. But I do know that it is outside the norm. It's not at all like any state system.
But this doesn't appear to take into account mitigating factors.
About to mention that.
Okay.
And you're right. I mean, this rough summary doesn't.
Right.
Judges are expected in a guideline system to sentence within that range, or they can explain why they don't want to do that. They can depart downward and give a lesser sentence and with mitigating circumstances, or they can depart upward. And the hallmark feature of that is there's more of an appellate review typically in a guideline system where the judge's explanation is subject to a little bit more scrutiny. It's not just an abuse of discretion standard that you see in non-guideline states. It's a more rigorous, potentially a more rigorous appellate review of the rationale of the judge in reaching a sentence length, either downward or upward from the guidelines. Yes, Judge.
Can I just throw in, Miles, the one feature that is similar to the federal system, though, is in every state that has adopted sentencing guidelines, it's discretionary. It's not mandatory because of the Booker decision, right? It can't be mandatory on the judge. It has to be discretionary. Am I right about that?
No.
Oh, okay, sorry.
There are states, Michigan is a good example of a state that had mandatory minimum guidelines, and their case came down that said, this is now an advisory set of guidelines.
It's the Lockwood.
Lockhart or Lock. Yeah, you're on it. Yeah, I read that case back when it came.
Lockridge.
Lockridge, yeah. And so the Michigan system is now an advisory system, and the judges still follow it. The problem, don't get me started on Michigan. Their guideline system is terrible, but I could tell you all about it if you want. So this is a picture of the Kansas non-drug grid. Kansas has a drug grid and a non-drug grid. And I'm showing you this to show you another kind of nifty feature, I think, of guideline systems, which is a dispositional guidance. So in the Kansas system, if you fall in one of the green boxes at the lower right-hand corner of their grid, the presumption is the judge is going to give you probation. Doesn't have to. The judge can depart upward, but the assumption and the presumption is a probation sentence. If you fall in one of the white boxes, the presumption is a prison sentence. Kansas is a little weird because they just the order that they range things in. They have their criminal history stacked towards the left. The worst criminal history is on the left side of their grid. I think every other system you look at It's the opposite, and the upper right-hand corner is the presumptive prison zone. The other interesting thing about Kansas is these border boxes. There's just 3 of them, but those are boxes where there is no presumption. The judges have freer range of discretion. They can pick from among the dispositional options without having to explain their logic or their reason. Michigan has that too. They call them straddle cells in Michigan. The same idea, wide open discretion within at least parts of the grid to do whatever seems appropriate in a given case. And the presumptions of dispositions are the same as the presumptions of a narrow range of punishment, in that a departure from that presumption also triggers the potential for the need for an explanation and the potential for appellate review. Any questions about that, Fred? You look well.
Kansas doesn't even allow the media to come into the hearings. No media at all.
You mean the Prisoner Review Board? Yeah. Yeah, so Kansas is an interesting example. We know Jonathan Ogletree, the chair of the Prisoner Review Board in Kansas. That's a state, they have sentencing guidelines, and they got rid of parole when they adopted guidelines. So the Prisoner Review Board still exists to hear legacy cases, but their main function these days is to set conditions for people who are being released, and they're being released without a release decision. And they have the power to revoke people. So that's I'm going to say a little bit about Illinois, which is another example like that. But Kansas is an interesting system. And by the way, I heard some people talk about the rebound. I was talking to the folks in Kansas just the other day, and they're projecting their population to shoot right back where it was pre-COVID. So the idea of this depiction is to show you a couple of sentencing guideline states that don't have parole, Kansas and North Carolina, and Texas, the state I'm most familiar with because I learned about criminal justice in Texas. So Kansas and North Carolina are determinate systems. When someone's being sent to prison, pretty much everybody knows the time that they're going to do. So this is an example of, in the judge's mind, they want the person to do 5 years. That's the hypothetical here. I want this defendant to do 5 years in prison. In Kansas, they're going to sentence them to 71 months, and the likelihood is they'll get out in 60 months. Same idea in North Carolina, sentenced to 84 months, likelihood of getting out in 60 months. You have to behave poorly in prison to end up serving that maximum amount. So so Kansas, that's about an 85% of max service. North Carolina, 71% of max being served. In Texas, by statute, the judge is picking from large ranges, 2 to 10, 2 to 20, 5 to 99 are the big ranges in Texas. And if the judge wanted someone to do 60 years, and I'm going to stipulate that this is a non-violent offense.
60 months.
60 months, thank you. The judge is going to sentence that person to 20 years. They're going to go for a very high number, because the judge knows that the way it works in Texas is that by statute, the person is going to be parole eligible at 1/4 of the maximum for a non-violent offense. So much of this gets at that degrees of indeterminacy. You've got this long period of time at the back end of the system where the parole board has released discretion. Another thing that creates is very long terms of parole supervision. People get out, if the person did get out in 5 years, they'd have 15 years to do on parole. And that is probably a system feature to be avoided if possible. Long periods of supervision post-release, not very productive, not a good use of supervision resources. We all know that the kind of behavior that gets people into trouble typically happens within the first year, 2 years, maybe 3 years. And those extended periods of back-end supervision are problematic. Yeah.
Just real quick before you move on, Carl, I think an important thing to note is when Carl said no parole, he means no parole board release decision, not no parole supervision. So there's a lot of systems who, they serve their time and then there's mandatory supervision terms after that, a parole board or paroling authority would then have that supervision, oversight, and revocation decision making. So just want to let you know that nuance, because I know for some people, when you hear no parole, you think no parole supervision, and that's not the case in one of those.
Yeah, that's a great point. So a little bit more about Texas, in this kind of diagram that Jen shared with you earlier. I kind of cooked this up to depict what I think is a fairly typical approach in many states, including Texas, that there is an increment of time that is up to a minimum that's defined either by the judge or by statute. And then there's a period when the person has reached their minimum and they're eligible to be released by a paroling authority. And very often in states, as Jen just alluded to, there's another increment where the person's going to be pushed out the door and put on supervision because we don't want them walking out on the street from administrative segregation and straight onto the public highway. So Texas back in the 70s realized that they were experiencing this max out or jam out problem, that people were getting out and without any services, without any supervision. So they adopted this overlay. So we had parole. We adopted what's called mandatory supervision, which in Texas operates as a feature of the good time that you accumulate. If you accumulate 10 years of good time on a 20-year sentence, and you max, and that triggers your release, you've got 10 more years to do on mandatory supervision because that's the equivalent of the time that you earned off your time inside.
Wouldn't it be a waste of resources, though? You're requiring somebody to spend 10 years on supervision, but if they don't have any issues after 3, 4, 5 years, why shouldn't they be discharged?
Right,
They
exactly.
paid restitution,
Absolutely. That's not a good feature of the Texas system, not my planning.
Okay.
This is a little further in the weeds than I meant to go, but Texas did come up with one weird solution to that. And it's a really complicated statute to read, but what they do is, if a person's, let's stick with that 10-year example, someone's on supervision for 10 years. If they manage to get to 5 years and a day, more than half, and then they get revoked, they get credit for all that street time. They don't just lose the street time and serve their sentence on the installment plan year after year. So there's this surviving past half your street time. This was enacted many years ago, but that was the Texas solution to that, some of that problem that the business causes. So in Texas, if a person commits a nonviolent offense, they are statutorily going to get released at 25%, and good time actually counts towards that 25%. So people are actually can serve with a parole release decision well under 25% of these long sentences.
So in Hawaii, a person can apply for reduction in minimum after they serve 1/3 of their longest minimum term, right? And so, like in the previous slide, you indicated that in Kansas, that the person might serve 60 out of 71. That's only a 14% reduction, and 60 out of 84 months for Carolina is like a 29% reduction. But the parole board here has greater discretion with respect to the reduction in minimum. Absolutely. And the person can apply every year from the date of their last application, whether it was approved or denied.
Yeah.
Okay.
Correct me if I'm wrong too. In a lot of determinant systems, they tend to set the maximums at a shorter range. So they may be serving, so they may be serving 75% of their term, but that term is typically shorter than an indeterminate sentence, if that makes sense.
Which is that's the sort of crucial feature of all these systems that makes it very difficult for a legislature to switch from a indeterminate system to a truth in sentencing approach, because you have to lower those big numbers in your penal code down from 99 to 20 and 20 down to 8 or whatever, to adjust for what would happen to your prison population when people are serving 75% of the sentence instead of 25%. You've got to rein in those big numbers that people like to say, and judges like to pronounce.
Well, it's rare here that we would get a Class C felon off the street. Normally, the person sentenced to probation, they've given chance after chance after chance, and by the time they're resentenced, like it's not uncommon for the HPA to see a Class C felon who's been on probation for 7, 8, 9 years, and by the time he comes to the HPA after finally being resentenced to prison, he's got 2.5 years of pre-sentence credits because of the intermittent times in jail. So when he comes to HPA, automatically they're at level 3 punishment because
criminal history.
Right. And so in those cases, it's hard then for that person to get done with all the programs before the maximum term comes up because they have all this previous intermittent periods in jail. Yeah.
Which reminds me, one of the things I like to do when I kind of dive into a state as a lawyer, I like to read the case law. And you can't read it all, but I read the case law that's about parole and mandatory minimums, things that sort of trigger interesting issues in the courts. And one of the reasons that's good, and I kind of sometimes share with my colleagues, is that all the cases that you read are like that. It's a person that's just cycling and cycling and cycling. We always kind of think of this stuff as a single person and with one case, and it's never that. It's always these really complicated patterns of behavior and sentences interwoven with each other. And it's always just really tricky, and it helps researchers understand the complexity of the data that they're looking at too, just to kind of see what's really happening in the system.
Were you talking anything about program and treatment, drug treatment, for example, as it relates to the sentencing structure?
I'm not going to do that today. I wasn't planning to. This is really kind of just the bare mechanics of how it works in these different systems. Just to finish out Texas, and I was involved in the legislative process back in the 90s. We had a 2-year sentencing commission and I was the staff director. And we rewrote our whole penal code. We went through and stripped out a bunch of stupid offenses that no one ever prosecuted, like theft of edible meat and just random stuff that some lobby got passed in years past, and really kind of tightened up the penal code, kept the same indeterminate structure, but settled on this resolution of how people are going to serve their time, that the nonviolent list of offenses serves a quarter, and what we call 3G in Texas, which is just an ancient statutory reference, those people have to serve 50% of the sentence. And that sort of big resolution that was with the prosecutors and all the players and everybody, that has really held up in Texas. That was enacted in 94, I think, and affected the penal code from 95 forward and has stood the test of time. So it's kind of an interesting approach. We're seeing more states, Arkansas, Missouri, other states really getting head up about the idea of getting to truth in sentencing, which again means some very tough votes for legislators if they're going to do it right. But there's a lot of chatter these days around the country about wanting more truth in sentencing. And that's sort of gratifying to me that Texas hasn't joined that, because we've settled on this approach that seems to work. We also built 100,000 prison beds in fairly short order, and that helps. So. I want to talk about a couple of guideline states, Pennsylvania first. And Pennsylvania uses advisory guidelines. These are not mandatory, but the compliance or the use of the guidelines is very well ingrained, and all the judges that are there have grown up in this system. It's been around for decades. They all understand it. And by the way, this is the Pennsylvania guideline system as of last year. They have done a full revamp of their guidelines, and it's not as pretty a picture, frankly. And I wanted to share with you what I think is a nice image of a guideline system. It's a little more nuanced. These are dispositional zones in the different colors, but they've done more work to have more dispositions, essentially. Straight probation. The very bottom left is, a fine only. The blue is the possibility of some intermediate sanctions mixed in with probation. Yellow, I think, is county jail and intermediate sanctions. Green is prison, presumptive prison. So in Pennsylvania, the guidelines are used for the judge to set the minimum. So again, narrow ranges, the whole thing I said about guidelines, but it's all about the judge setting the minimum. The judge in Pennsylvania also is expected to set the maximum, which is going to be the outer limits of the parole board's authority. And by law, the judge in Pennsylvania has to set a maximum that is at least 2 times more than the minimum. And the reason for that is they want the parole board to have cases. They want there to be a discretionary period. They don't want the judge to eat up the whole max by setting a minimum that's right below the max. So they're forced to pick a number that's 2 times bigger or more. The problem in Pennsylvania, and we saw this when we looked at the data there, 3, 4, or more times is what's actually happening, and particularly with people with less serious offenses. They get a pretty low number up front that they're going to serve, a minimum number, but the max number is much, much higher. And then that leads again to this problem of people being under supervision for an extended period of time. Gives the parole board a lot of discretion. But the parole board does its thing and people get out and they have this much longer maximum that they have to serve. We did a project in Pennsylvania a few years ago, and one of the big presenting problems there was people with what they call short mins, a person who comes to prison with a short minimum sentence. They've got some jail credit, they might have 4, 5, 6 months of jail credit. They get to prison, they're parole eligible pretty much that day. And the parole board goes through their whole process, and it takes months for them to do all the things that statute tells them they have to do, a big checklist to get somebody ready for a parole vote and a release. And that's dead time, as we heard talked about in our community meeting yesterday. People just sitting around waiting for the parole board to do. And it's also the most expensive thing that prisons do is that reception, right? The diagnostic process. It's that front end of a prison sentence. And they were vexed by that. They wanted to do something different. And so a change in parole policy was enacted. It's called short sentence parole. And it's essentially an automatic parole. That's what the prosecutors refer to it as. But it's in statute, it's called short sentence parole. And it's a way to get people through that process by stripping away some of the requirements that the parole board had to jump through for people that really need those requirements that are going to serve a longer term in prison. It's just a way to short circuit that process and on average save about 4 months of downtime that people were spending in prison waiting to be paroled and parole eligible the entire time. I mention all that just to point out that we've heard about a similar, we heard this last night, about a dead time issue under the current system in Hawaii, where people spend some months waiting for that minimum hearing, and while they're waiting to know what their minimum is, they're not eligible for programs, or they're not going to get plugged into programs. So this is an example of a state that kind of tackled this from a different system, but tackled a similar problem with an approach to a change in parole policy. It would be certainly a possibility here in Hawaii. A little bit about Michigan. Michigan also has sentencing guidelines, terrible set of guidelines. They have 9 grids. The guidelines have very wide ranges, and so they don't provide much guidance is the bottom line. We showed them all kinds of examples of wildly different sentencing by judges under their guidelines. It was just not a good example of a tight guideline system. But the guidelines are all about the minimum, just like Pennsylvania. The guidelines are driven, the judges setting the minimum is driven by the sentencing guidelines. And also like Pennsylvania, there's a law that says you can't eat up the maximum. In Michigan, the law is the minimum can't be more than 2/3 of the maximum. And one of the reasons for that, it's interesting, Michigan actually has indeterminate sentencing written into their state constitution from like 1803, that they're going to have an indeterminate system. And so what was happening is that some judge sentenced a guy to 14 years and 11 months out of a 15-year sentence. And the courts reversed and said, that's not an indeterminate sentence. And that case law was respected. And ultimately, the legislature passed a law that said basically the same thing. The case law had said can't exceed 2/3, and the legislature enshrined that in statute. This phrase truth in sentencing comes up a lot in Michigan. But what it means for them is there's no good time towards the minimum. What the judge said was going to be the minimum absolutely is going to happen. We know there's discretion. The parole board has authority after that. But we're going to have truth about what the minimum is when pronounced in court. Another thing I was always struck by in Pennsylvania is that if you look at a graph over time of their prison population and their parole approval rate, it's a mirror image. The 2 lines are like this. So the parole approval rate goes up, prison population's down. Parole approval rate goes down, prison population's up. It's like a perfect mirror image. So that's emblematic to me of a system where people need to recognize that it's not the flow of people into prison that's causing the prison population. In fact, we graph the flow into prison over time, and it's pretty flat. But that approval rate and the prison population is fluctuating in tandem with one another, very constant over time. Just a thing to recognize about states with indeterminate systems like yours, that your prison population is going to be very much a feature of what's happening with your parole offense.
You hear about Tennessee's legislature passing the truth in sentencing?
Yes.
That's supposed to take effect soon?
Tennessee, I'll tell you a little bit. Tennessee, a couple years ago, and this was Speaker Sexton, Cameron Sexton, who became famous for other reasons. He got really head up about truth in sentencing, and he passed a bill that basically created a list of offenses that have to serve their whole sentence without any erosion by good time or parole. Last session, they did something really kind of sneaky, I thought. They created a new entity called the Prisoner Conduct Review Board. And it's a bunch of political appointees. And the wardens in Tennessee prisons have to tell those folks every month, I think this guy deserves 16 days of credit for this month. And the board gets to decide whether that's going to happen or not. So they've created this new system that's going to come into effect that seems like a tricky way to achieve more truth in sentencing by denying people good time, or at least chilling the impulse of wardens to award people good time by creating this whole separate entity that has the power to give or take away that authority. Really interesting. West Virginia is not a good example, to say that up front. It's an indeterminate system, has a parole board, doesn't have guidelines. And the other weird feature of West Virginia, it's not a model penal code state. And so what you see is you scroll through the penal code in West Virginia, every offense has a penalty attached to it. It doesn't say like this is a level 1 felony or a class B or class C felony. It says the penalty for this is 10 years, and there's very little rhyme or reason. They haven't gone through and ranked their offenses in a logical progression. So that's a feature that you all don't have in Hawaii. So you check that box. This is not a unique problem, but a West Virginia problem. But they also have this. They have pretty generous good. And what they're experiencing, and this is 10 years ago that this chart was created, but it's still true. There's parole and good time laws create a situation where a lot of people can max out. People also, we interviewed a bunch of inmates in their system, and they were frustrated by being denied parole over and over again. And they would get a sentence like, one guy said, yeah, my sentence was 2 to 10, but I call it 2 to win, because when we were interviewing people that had deliberately said, I don't want to talk to the parole board anymore. I'm done. I'm gonna do my time. I want to get out. I want to max out. So we were trying to get at what's going on with that. And West Virginia has a problem with that. Their system tends to push people out the back without any supervision. So just an example of things to avoid. Illinois is the state that I mentioned earlier that's kind of like Kansas in that 1978, Illinois eliminated parole release, but they kept a prisoner review board. They literally changed the statute to say this is no longer called the parole board. Now we're going to call it the prisoner review board. And the PRB's role, like in Kansas, is not to make release decisions. It's only to make condition setting decisions and then to have the power to revoke people. They also have they have authority to relitigate the removal of good time from people in Illinois, to provide a layer of due process. If the corrections agency wants to take good time away from people, hardly ever happens, not really much of their authority. And of course they have clemency, stuff like that, but their main job, the PRB's main job, is setting conditions and litigating revocations. Yeah.
So is this just a paper review versus a in-person hearing? Because
Yes.
that's what some states do.
It
They
is.
just do a paper review.
It is, and it creates so much friction between the Department of Corrections, which has held these people and put them in programming and recommended conditions, and the PRB folks who are setting conditions seemingly without much regard for the recommendations. So there's this headbutting going on between the two agencies, not unique between parole and corrections. You see some conflicts between agencies trying to get programs timed right and all that. But there's some seemingly sort of unique tension between the PRB and the Illinois Department of Corrections because of what I said. That condition setting feature creates opportunities for disagreement. And there you have it. The other thing to note about Illinois is they don't have sentencing guidelines, so they're not like Kansas in that regard, and they get a wild variety of sentences. But they also have very generous good time. I think Illinois is actually characterized as a pretty indeterminate system, a moderately indeterminate system, even though they don't have parole release, but it's because they have quite generous good time. So people are serving right out, you know you're going to serve half your sentence just because you know you're going to get that kind of automatic good time. Chairman, you mentioned Missouri, and I wanted to go into a little more detail about Missouri because it's a really interesting system, and it's the one system that I think is kind of analogous to yours, in that the Missouri Parole Board, by policy and under statutory authority, establishes minimum time to serve for a lot of offenses, most offenses in Missouri. The parole board is setting the minimums, but they're not doing it the way you do it by any means. They're doing it not through a hearing. It's not like a second sentencing hearing. It's just through policy. They have a very elaborate, they call it the blue book. You've looked at it. This is one page out of an appendix of the blue book, and they have these massive charts that depict what increments someone's going to serve before they're going to look at them for a parole release decision. And the increments are based on their categorization of the offense type: drug, felon, violent, sex, etc., and a risk assessment. So they're basing everything on risk and offense. And the increments that they're setting range from low risk people getting heard by the parole board at 15% at the very lowest, 15 to 20%. Very high risk people getting a hearing before the parole board at 40% to 66%. And I'll say more about that 66 in a sec. See if there's anything else I want to lift off this page.
Does the Missouri, they can extend the sentence, can they not?
They can't extend the sentence, but well, let me go to the next page, Chairman, and I'll get into that. So Missouri has a feature that's kind of like the Texas thing I was talking about. They call it conditional release, but it's the same idea. It's reaching that 2/3 mark in your sentence where we're going to push you out the door because we want you to be under supervision for the last year. The statute just spells out there's going to be these increments of time that people are going to be under conditional release, and that's part of the sentence. But the assumption, the presumption is you're out the door, you're on supervision. The parole board does have the authority to not abide by that 66%. They have the authority to hold essentially a due process disciplinary hearing at the instigation of the Department of Corrections. And I don't think this ever happens, rarely if ever. But they can push past that conditional release date and keep the person in prison longer because they're really acting up and creating problems. So the idea of this table was to show legislators in Missouri how their system works. What we discovered is that the policymakers who have devised this system do not understand it. And that may be true in other states, but it was like in your face kind of thing in Missouri. And they want more of a truth in sentencing system because they don't understand the system that they have set up. And a lot of the reason for that is this fairly dense parole manual that creates all these increments of time. So what this one-page summary shows them is here's the way it works in your state. Under statute, at the top part of this graph, you've set aside a list of offenses that have to serve 85%. You set aside a list of offenses that if you repeat those offenses, they have to serve either 40, 50, or 80%, depending on how many times you've done it. And so they've got these sort of mandatory minimums before parole eligibility spelled out in the statute. And everything that's not covered by those minimums is covered by the parole board policy. So which is most of the offenses, certainly all the property and drug offenses that tend to be the big volume kind of thing. So the idea of this was to just show them it's not that complicated. We can dumb it down to one page here. We didn't say that, of course. But we went from here to actually we have a technology partner, and they've created a tool for judges and prosecutors and defense lawyers to plug in an offense and a charge code and plug in a hypothetical sentence for that offense, and find out from deeper logic and algorithms what that minimum is gonna be and what that conditional release time is gonna be. And they also have to plug in how much time, how much jail credit time the person's gonna get, which really is just a matter of where you're gonna be inside, not whether you're gonna be inside. So we've created this tool for the sentencing officials in Missouri to better understand what would happen if they picked a given sentence. Of course, it gets really complicated, consecutive sentences, so complicated, we haven't been able to incorporate them into the tool yet. But it's a pretty nifty feature that we're devising for them so they can better understand their own system. But again, I would just reinforce that we think of Hawaii as completely unique, but Missouri is kind of close in this one sense that by policy, not by hearings, that the Missouri Paroling Authority is creating minimums for most of the people in their system. 3 other states have an analogous or analogous enough to Hawaii to mention to you here today: Iowa, Utah, North Dakota. And the reason for the analogy is these are 3 states where when someone gets sent to prison, they're parole eligible. That's it. They walk in the door parole eligible. So the parole board they're not setting the minimum, but the minimum is that, the minimum is there. And it's the whole time the person's in prison. So sort of in a theoretical sense, the paroling authority in these 3 states has a vast amount of discretion to setting aside mandatory minimums and so forth to act on a release decision, not completely unlike Hawaii. So worth noting that this is another pretty pointed analogy. Okay, I'm going to recap a little bit as soon as the slide changes. Wow. Swear it's a different slide on the computer here. There it is. All right, just recap. Kansas and North Carolina, very tight sentencing guidelines, no parole, and people do a pretty high percentage of the max that they're given. In Texas, judge sets the max only. Minimums are set by statute at a quarter or a half, and good time factors into those things. Pennsylvania has sentencing guidelines for the minimum. The judge sets the minimum and the maximum. Max has got to be 2 times more. And I mentioned this short sentence issue about getting people through the system that don't necessarily need to have a full-blown parole process.
On that short prison requirement sentence you talked about, I would be interested to know what the recidivism rate for those were, because it seems like they get expedited to the system without programming. So it'd be interesting to see how many of them come back and how often.
I think there's some research that the Sentencing Commission has done. They've got a really healthy, big staff Sentencing Commission, and the research director is a buddy of mine. I'm pretty sure they've done some look at that. Brett Buckland with their department is also a pretty prominent corrections researcher. So I can look into that.
Okay.
I'm pretty sure I've seen that they have done that. But just to be clear, the idea of that was, yeah, we know they need programming, but we're a system where we can plug them into programming on parole supervision. They're gonna, they need to do, CBI or whatever they're gonna do, but we can run them through this process, get them back on supervision, and to the extent that programming is indicated, we can provide that pretty effectively through the parole system, the supervision system. Michigan, also a guideline state, judges set the minimum and the maximum. You got the 2/3 rule for the maximum to preserve, again, parole discretion, and this issue that the prison population is determined by the parole rate. West Virginia, a bad example, the confusion of variable minimums by statute at good time, pushing people into max outs. Illinois eliminated parole, but preserved a PRB, and they have coordination challenges. Missouri has minimums for many offenses set by the parole board based on rules that they publish that are online, that are based on offense type and risk. And then this triumvirate of 3 states where people are basically generally parole eligible when they walk in the door. Yes.
Okay, I have a little bit of a question around, so I'm watching and listening to apply to victims issues.
Yeah.
And so is it possible to take those states that you have listed on page 41 and talking about and look at in terms of the minimum hearing if there's, yeah, in those states, constitutional or statutory rights for crime victims and how it relates to minimum hearings, either the notice of the hearing, participation, input, safety issues around that, and notice of outcomes. Is there a way to gather that information? We don't have a constitutional right for crime victims here, but we do have statutory
Well,
right.
a couple things. One, none of those states have minimum hearings like Hawaii, so they all have parole. I mean, all the states that have a parole board have parole release hearings. And I will venture a guess, because I've looked at all these states, that every single one of them has a statutory right, at least, for victim participation, victim notification, and the option to participate. Some states default to assuming the victim wants notification. Some states default to assuming they don't and asking them. There's the issue of whether to bother the victim, basically. But I think every single state that I've ever looked at has both notification and the opportunity to participate in the parole decision. The extent to which the statute spells out what that participation looks like, what relevance it would have, that kind of thing. I think there may be states that say the victim's input should be limited to conditions of release, or something that's not just about relitigating how horrible the offense was in the first place, but is about fear for safety today. And if this person gets out, I want them to be on electronic monitoring, that
or even current incidents.
Right,
Yeah.
right. So written letters and that kind of stuff. So yeah, I think that is pretty much a feature of all these parole systems as far as I know. But I can double check that.
That would be great.
Yeah.
Any of the scroll systems that you've looked at, I'm assuming most of them have some type of version. We have the Victim Bill of Rights, where the surviving family members are to come in and testify, give statements at the initial term. Do any states allow for defense witnesses? Our system does not allow that. Exclusively the victims that they second by the apple, for a better statement, as minimum term. Any other states you've looked at allow defense witnesses to come? It's taken to litigation.
None comes to mind. I don't think I've ever looked for that, but none comes to mind. Did you say that that 8 states have that? Is that what?
No, I said don't. Any state that has that.
Okay.
But I haven't made the extensive study that you have. Look at obviously Hawaii, and primarily in Hawaii, we have a trial where we please and the victims testify there or make statements, and then another bite of the apple for the parole board at the minimum term, and that goes unanswered because we're presenting litigating witnesses.
Texas, I know, kind of wrestled with this some years ago, and it was actually kind of a scandal thing. It was about people who had worked for the system, who retired or whatever and became parole consultants. And so the legislature passed a law limiting who could be a parole consultant and requiring it to be a lawyer. It was regulating what they saw as kind of a revolving door issue. But the upshot is that people who can afford to pay for a lawyer in Texas can have a defense lawyer, speak on their behalf at a parole release hearing. And I think that's probably, I don't know if that's common, but I think that many states would allow that, but I'm not for sure. But it's not like you're giving someone a lawyer to do that. You're letting someone have a lawyer if they can afford it.
Well, okay, even though defense can't bring witnesses before the parole board for the minimum term hearing, and I'm not saying it's equal, but that doesn't prevent the defense counsel from providing written comments from those people to present to the parole board for review and consideration, right? And here, every person appearing for the parole board is entitled to an attorney, and if you can't afford one, then the state will provide you
for the minimum hearing
and parole violation.
Violations, right?
No, minimum, parole consideration, and parole violation.
All three.
I would submit from the defense side that therein lies these problems with defense across the board. That you try a case before a judge who has all the knowledge, all the information, and you're looking for a parole board where we have victims coming in and making another pitch when there's an open sentence. So you get another opportunity to max out a sentence that a judge was unable to determine or allowed to enter on behalf of the defendant. I see that as inherently inequitable.
And that, I mean, I would say that's true in the states where, which again, I think is virtually every state where victims are allowed to interact in the parole release decision, that opportunity exists in those states as well. It's not a three-part opportunity like it is here in Hawaii, at least a two-part, minimum hearing and then parole release here.
And again, I agree with what Tommy was saying. Yes, we submit letters on behalf of, frankly, live testimony makes a big difference. That's why it's so effective at the minimum term. And I understand what Steve is saying, the prosecutor's office, this county, having the prosecutor appear at the minimum term hearing, but they have a victim advocate there and they have the victim there, and the defendant is left speechless, only able to submit letters. So it's been a constant problem, and I would hope that we can do some kind of resolution that can try to make recommendations on how to improve the system.
Yeah, well, and that's an example, as I alluded earlier, if this group is unable to settle on, let's change this system in a big way, that's the kind of thing that we might be saying, here's a modification to what happens now. I don't know if there would be consensus about that. I'm not presuming that. In fact, I'm about to be told no.
A little bit of perspective. I mean, we appreciate and enjoy Miles. But for minimum,
That's not what you said.
for minimum hearing, we're not trying to retry the case. We're looking what fits into the categories, levels of punishment, what nature of offense, serious injuries, conviction history, character, and attitude, efforts to live a pro-social life, probation revocation, that type of stuff. So the line of questioning to the inmate and or the defense attorney and or the prosecutor is based on that. So we're not trying to ascertain guilt or innocence.
Yeah.
And we have to caution all parties of that. And when the defense does present their case, we afford the victims an opportunity to leave the session because in respect to the defense counsel's position, they may be saying things that may prove offensive to the victim. But some elect to stay because they want to hear it and some elect to leave. But all parties are afforded opportunity. But again, minimum hearings are not to retry a case.
Yeah.
Plain and simple.
Yeah, I don't think folks are confused about that.
I have a very clear.
Moving on.
Thanks.
All right, moving on. Jennifer's going to jump in here, but let me kind of ramp up and getting into some discussion mode. Not that we've had too much trouble seeing this. Okay, this one. So we've looked at some other systems, and again, I don't want to pretend this is like a massive study of all these other state systems, but just, again, to give you a flavor of how this kind of stuff works in some other states, good and bad. Some examples of things that might make sense here or not. But we've got these other number 1 and number 3, and 4 is just about kind of reaching a conclusion. But I just want to hesitate here and see if there are any other questions about what we want to know more about some other state systems, including, and I registered your question.
Was any comparison to other unified jurisdictions?
No, and by unified, what we mean is a system, Alaska, Hawaii, Rhode Island, and a couple others, Connecticut, I think. Systems where jails and prisons are all one agency, essentially. And there's only 6 or 8 such systems. But that's not really, to me, that's not the issue. The issue is the ruling question. And there's a remarkably apt publication that NIC did like 20 or 30 years ago that describes those state systems. I can send that to you. But it's, I'm not sure, but help me understand.
I
how
would
that-
just want to see how their parole system is set up too, since they're unified, they're smaller states.
Yeah.
So in smaller states, you normally have agencies pulling more than their fair share of weight to some
Yeah,
degree.
yeah, that's a good.
So I'd be interested to see how their systems are set up in relation to their unified system.
Okay, that's a great idea. Yeah.
And to add on to that, because Hawaii's jail transitioned to prison, two separate entities, so should supposedly, but it's under one department. So the transfer of information and files becomes another thing when setting minimum.
And I would assume is more efficient, more
Sure.
dialed in, right? Because it's just one agency.
Yeah, but again, Hawaii has had this recent history of unified system, which included law enforcement and narcotics enforcement, right, under the director's office.
And the bill, there wasn't a bill passed that
Yeah, we separate.
against this.
Yeah, separate out.
Okay, I want to mention one other model, which is, and I alluded to this an hour ago. Still not up. So the American Law Institute, which created the model penal code back in the 60s, they had about a 10-year process of creating a new model penal code. And this is I got a free copy of this book. I was very pleased to get this. This is a photo of my copy. It's just about sentencing, and it's an amazing resource. You don't have to agree with anything in it, but it has all this research and commentary about what they suggest as black letter law for states to consider. But this is my boiling down of a big volume of stuff. What they suggest that states should have is a sentencing commission and real sentencing guidelines, like I described at the outset. States should make probation available, and it should have what I call it modern limitations, which means not ridiculously long sentences on probation, the ability to sanction people without full-blown revocation, things like that that are, I think, familiar. They recommend that people who are incarcerated should have access to modest good time. I think they would say something like a 15% availability, 15-20% good time. Many of the states that we talked about today have much more than that. Texas, Missouri, Illinois, states that are, it's 1-for-1 good time, for example. The model penal code folks said, let's get rid of parole altogether. We don't like parole. But we think that states should have a judicial function where there's a second look. And you're starting to hear more talk around the country about this idea of a second look. California has enacted a couple of statutes that provide for a judicial second look. I think the District of Columbia has a second look. But so it's an interesting thing. They're suggesting no parole, but create another way that people have access to another revisitation of that long sentence, if the same. And they suggest that if people have a sentence of 15 or 20 years, that would be the trigger for having this ability to have judges do sort of a paroling type function. So as far as I know, there isn't a single state that is saying, you betcha, we want that. And by the way, this is like the opposite of the Hawaii system, right? You don't have guidelines. Yeah, everything in here is something that you don't have or have, and they say you shouldn't have. But I think it's, we're doing a survey here. So I think it's important to note what the model penal code is suggesting. And I want to pluck out a couple of high level actual statements out of the model penal code. Because they start out with a section 1, right at the very beginning, section 1.02. What are the purposes of sentencing? We've kind of talked around this. We had a little bit of conversation last night about what should the purpose of this thing be? And the model penal code folks divide it into two categories. They talk about the purposes of sentencing individuals and the purpose of a sentencing system. Systematically, what should that look like? So this is their a sort of boiled down version of what they say about sentencing individuals. Proportionality, no more severe than necessary. And number 2 is like where the horse is buried, right? That's what my contracts teacher used to say. Everything that everyone's ever thought about sentencing policy is buried in number 2: rehabilitation, deterrence, incapacitation, restitution. That's kind of the stuff that we all as regular people think about is the purpose of sentencing. They also, and I think this is this sentencing at the systemic level is worth pausing. Because this gets at the kinds of things that a group like this, I think, should be thinking about. Preserving judicial discretion to individualize sentences. And I think you have that in Hawaii. Producing sentences that are uniform in their reasoned pursuit of those individual goals. Eliminating inequities across population groups, definitely a concern we've heard about here in Hawaii. Making sure there's adequate resources to carry out sentences, huge issue in every single state. Prison is a free resource, everything else has to beg for money, right? And prisons do too, don't get me wrong. But the mentality is I can send someone off to prison and they'll take care of it. But if I want to put them on probation in my probation department, I don't have the resources, etc. Humane administration, promoting research, Aaron, and making sure there's data collection and all that. And these are features of systems that have sentencing guidelines. One of the things I like about sentencing guideline systems is they're kind of set up to collect granular research on what's happening with their system because they have this rigor and they have a group of people that are charged by statute watching what's happening over time. And again, increasing transparency, and that's another word that we've heard come up here in Hawaii, the concern about transparency. So just to round that out, I just want to mention that you have in statute sort of a similar construct. Your legislature has directed to courts many of these same ideas. What courts should be thinking about when they sentence someone, and this is kind of ironic because of what I think is a fairly limited role of the courts in your system, but these are the things that the legislature says that courts should be thinking about in individual sentencing decisions. Seriousness of the offense, respect for the law, and this is very typical. You see a statute like this in just about any state you want to look at. Kind of, not something you can litigate over, not something you can challenge, but a general guidance about what sentences should look like. So, this is where I shut up, maybe. And I want to get you all to tell us what problems you think we're trying to solve. Representative, this might be a good chance for you. You said you didn't have a predetermined outcome, but are there problems that you have detected that you think we should be looking at? Is transparency an issue? Is consistency in decisions an issue, etc.? This short list of the kinds of things that people that are wrestling with sentencing tend to wrestle.
Well, my concern was whether there was redundancy in the system. And it's been referred to, in terms of having the judge review obviously the case and having the parole board re-review the circumstances.
Right.
So that was the one thing that came to mind.
Okay. What else?
So, I think you guys have come to a really good point here, and I'm gonna skip a little bit to the next slide, if that's okay, just where I'm coming to at this point, but in the goals that your organization set out in the early slide and the model penal codes, the references that you just made to the model penal code in this slide you have up there right now, discuss things like recidivism, reducing recidivism. In the work that we're going to be doing in this group, I'm interested in what kind of data might be out there to help us determine among all these systems, different sentencing systems around the country. I'm really interested to know what the impact of these different systems is on the individual being sentenced, and what is the benefit to the community and the victims in terms of public safety, right? So those are difficult things to measure in terms of what factors influence those various things, right? To Tommy's point earlier, you have an underfunded correctional system that impacts recidivism in a way that you may not be able to also measure some other things, but has it been done or can it be done? I'm looking at Aaron. Where inappropriate, if I'm using the right term, I may not be, it's been a long time since I took statistics, but a regression analysis can be done to determine what is the meaningful impact of these different sentencing structures on recidivism rates, on public safety as measured by crime rates or some other measure. Because we're all going to be talking, I think, in a lot of ways anecdotally about some of these things. We all have different opinions on which way is best and why one way might be better than another. But for these kind of bigger issues, what is there data out there, or is there a way to analyze data in a way that will help us focus on some of those things?
Honestly, I don't think it would be possible to credibly compare totally different systems by their impact on recidivism. It's very possible to, we did this in Pennsylvania. We looked at people who were statistically identical or very similar. Propensity score matching is what the researchers call it. So you pick a bunch of people that look the same on paper, but they got different dispositions. Some of them got probation, some of them got jail, some of them got prison, some of them got treatment in prison. And you compare recidivism that way in a given state. And you can do that. And you can see that the people that got treatment, sure enough, they had 10% point lower recidivism. So we can do that. And that's quite possible with a big enough N, if you've got enough people to do statistical analysis. But comparing systems, I think that's impossible.
Yeah, I thought that was going to be your answer.
I'm glad you thought.
But I wanted to answer the question because, I think just around the table in terms of where we're going to have common ground, there isn't anyone at the table that's going to say, well, I'm not in favor of reducing recidivism. Right. There isn't anyone at the table who's going to say, I'm not in favor of increased public safety, right? And so what is the impact we can have on those types of issues?
Well, I do think that we can have some conversation about whether your system is optimizing the opportunity to reduce recidivism. Whether you have just enough slots in programs. My guess is no. No, I've never seen a state that does. Whether the timing of when people can get into these programs vis-a-vis their release date is queued up nicely. Whether there's enough resources and enough knowledge to do the timing right. And to plug people into programs that we know are evidence-based. I mean, there's things we can talk about Hawaii's system that would get at the issue of reducing recidivism, I believe.
And I think that really brings out the question of the scope of the task force, right? And because there's the scope of the minimum sentencing, and setting that minimum term, but there's also intersections with other things that, can come up within that, and are any of those other things that intersect with that area, things that the task force wants to look at, or, provide recommendations in a report, but it may not necessarily be legislative recommendations. I think those are some things that are probably that we can foresee coming up throughout the next year of just, through the work and kind of looking at things, kind of how far in or outside of the scope that the task force wants to stay in terms of recommendations and the work, because there's definitely lots of intersection that can happen.
I agree with David. This is critical to all of us here. The recidivism rate here in Hawaii is a particular concern because everyone gets out at some point in our community. They don't travel to the mainland, they stay here within the islands. So we're dealing with this multi-generational problem. I know that pretty much all of us have seen this, family members, grandparents, the grandkids, the great-grandkids in the system. And unlike other states where they're contiguous, they can travel elsewhere, start over. It's difficult because we're limited to these islands into our population that stays here. It's still a problem that we have to address. The recidivism, they consider what you do about minimum term sentencing.
Well, that's a little bit of perspective and history, so we all know where Hawaii Paroling Authority has been, because it's always been part of the executive branch. And legislative, judiciary, executive branch sharing the responsibility, didn't it? So in 1956, the board became the center of attention and was criticized for its unequal sentences. So in 58, they hired, I guess, this consultant, Norman Hayner, from, I think it was Michigan, or Washington. And he did the study called Sentencing and Administrative Board. He released it in 1958. And it takes into consideration politics. It takes into consideration the mandates and by law. But his bottom line in his final summary or remarks is, having more facts, the board is able to make more intelligent judgments. And he says, when laws are sufficiently flexible, sentences can later be reconsidered in light of progress and are readjusted appropriately, meaning for the ROMs. Yep. So he says, one of the weaknesses of sentencing judges is a wide variability of sentences for offenders who have committed similar crimes and have similar prior records and have similar personal characteristics. So what we're entertaining is nothing new. It's cyclic, like back in the 1930s. We had pretty much the same issue, but the legislature has renamed it and everything else. But people should be aware that the minimums and the sentences that the parole board was involved with back then, whatever recommendations the parole board had to be approved first by the governor. And then later it was transferred to the judiciary and the courts. So whatever minimums that the board of paroles and pardons came up with, it had to be approved by the judge up until 1962, when the Paroling Authority was given complete autonomy in which to fix the minimums, as well as later on reduce the minimums and parole earlier. Just factoids.
You know, one thing I think that, since part of the task of this group is to decide should the minimum still stay with the paroling authority or go to the judge, I think it would be really helpful if we have a discussion about exactly what happens when judges do the sentencing, what information they have to base that on, what this hearing looks like, and the paroling authority. Because I know I have learned a lot about what happens at the paroling authority because Cheryl worked there for a couple of years. I didn't realize certain things that they do or information they consider. And so I really think, and I think a lot of folks in the room probably don't really know what goes on there, or they may have a certain idea what the judges consider or know about cases. So I think that would be worth spending some time on, maybe in the next meeting, just talking about both those. I think Kara from your group went to paroling authority hearings. It might be useful to hear from her, so it's not just met at the board. But anyway.
Any more comments on the presentation here or from the community on the internet?
I think there was reference to this next slide a moment ago. So this is part of the kind of ongoing discussion. What if we can see it in the data, what would you be interested in seeing? These are some of our thoughts about what would be, you know, right in scope if there is data to know these things. And I think to some extent there is. I've seen the annual reports that HPA publishes. And the reports that are published are down to the individual offense by class, but also by individual offense. So a lot of information about the minimums that are being set. And you can look back over time at those annual reports. But again, this is a sort of a hypothetical or to get your minds working about what we should be curious to see or fascinated to see if we can find data that illuminates the issue. And I don't know, yeah, I guess this includes this idea of comparing HPA minimums to judicial minimums, which is squarely in scope in the HCR 23 mandate to look at that. To me, that's a data question, period. But what does it look like when judges set these lower than mandatory minimums and the HPA sets a different mandatory minimum? I don't know how often that happens, if it's enough that there's really much data, or if it's just anecdotes. It doesn't look from the judge like that's a very common occurrence.
Well, from the parole board side, because we see it everyone, it's becoming, we see more repeat offenders. We see 1.6, 1.8, sometimes 1 year or 2 years on open files. And then we see a lot of credit for time served, either because of pretrial or probation, which may leave 1.5 years on an open file. So there's a lot of things that can complicate the length of time an individual stays incarcerated. I think, I'm not sure if George King, the statistician, can pull everything up, but the data a lot of times does not reflect everything that it would purport to show.
Yeah, I got what you mean. And by the way, we have a relationship with George from past generation, so he's a great resource for us. He will certainly be on our phone list to find out what is possible with APD.
15 minutes left in the meeting. Thank you, everybody, for your comments. Is there any more comments from the online community at this time?
I just had one, Mark.
Go ahead.
If they don't have anything. When we talk about recidivism, the recidivism rate in Hawaii is high, but a lot of it is due to our definition of recidivism. So let me kind of explain a little bit. Our definition, Judiciary's Public Safety, Department of Health, HPA's recidivism rate is based on any new arrest, regardless of the outcome of the arrest. The problem is cases aren't adjudicated for 2 years down the line from the date of arrest. If a person is found not guilty or acquitted, then that's still recidivism. So I had already talked to the Interagency Council on Immunity Sanctions. We probably need to look at how we define recidivism in the state, because I think we're shooting ourselves in the foot because it's so rigid.
Yeah, that's guaranteed to be the highest possible rate you could calculate.
Correct.
Because of that.
Right.
And you're starting to see a lot, you want to see that arrest, but then also new conviction and then reincarceration, right? So, looking at each of those measures gives you a little bit better picture of everything that's going on.
Right now, it's painted with a broad brush.
The one that most state corrections agencies publish is return to incarceration, because they know we had this guy, we let him out, 3 years later, he's back. So they'll look at a 2018 cohort and see who shows up three years later. So that's the most susceptible to comparison, even though even that gets tricky. But in terms of comparing systems across states, return to incarceration tends to be the one that most states publish.
And that's usually because that's the data they have, right? So they're not having to intersect it with court data or law enforcement data.
Just to clear up stats, we got it cleaned up a little while ago. Some of our stats would show something like 800, 900 parole violators in custody. So I think with Max and Tommy, they helped clean up that so that you show the actual number of parole violators awaiting revocation hearing. So it comes down to less than 300, who are awaiting hearing. And those who have been revoked, which are non-Act 139, which is what we took a lesson from the GRI, a lot of those are back to sentence felon coming back for parole consideration. Especially Eric.
Here, can I just add real quick from the judiciary's perspective? I think that it is very important that we clarify what it is that our mission is going to be here. It is just a matter of deciding whether the parole board should set minimums or the court should set minimums. And we decide as a group, okay, we're just gonna recommend that we delete HRS 706-669 and just say, okay, you know, we're gonna give the courts that authority. Then I agree. I think we do have a very long, generous time horizon here, because I think we can get that decision done. But, you know, part of our task as I read the concurrent resolution here is to propose and suggest, you know, legislation. And I think Carl and Jennifer will both agree that if part of our, you know, our perspective from the judiciary is, okay, if as a group, we're going to decide that the parole board is no longer in the minimum business, and that's our kuleana. Okay, now what? What does that look like? Right? And I think they'll confirm that some of these states that have been cited and the sentencing schemes that have been put forward, these have taken years to develop through trial and error and court challenge and reworking. And it's not just something that is as simple as us saying, okay, we're going to adopt, you know, Missouri's approach, or we're going to adopt Michigan's approach. It's a much longer time horizon and a much larger task than I think that what we're allowed to do here in the time that we have. So I would just ask that we really focus on what it is that we want to accomplish as a group here.
Can I bring up one thing too? Because I just thought it was really interesting that there's a third option that I never thought about or considered, and that's I don't remember which state it was, but you had talked about how like some of the minimums are set by policy or like very specific stand, like it's not necessarily a judge or parole who are setting the minimum, it's actually like embedded, and I don't know, I just didn't even consider that.
By statute.
Yeah, by statute, and so like.
Or by parole, the Missouri parole guidelines, they do that, that may be what you.
Carl, is
Yeah.
it correct that in Mississippi, they don't set a minimum?
I don't know.
I think in Mississippi, there is no minimum set, and by statute, you're eligible for parole after you've served 25% of your sentence.
That's like some other state.
And then it's up to the parole board to determine how long someone's gonna serve based upon the programming they've done, their good time credit, things like that. So, I mean, that's also an option that maybe nobody sets them in.
Yeah, the state, you could just say minimum is 1/3 or 1/4.
And our goal with sharing the state examples is not to say like, oh, recreate X model, or, you know, these are kind of the options to pick from. It's just to give an idea of different systems and how different systems can function and do function, you know, but figuring out what is going to be the best for Hawaii. And it may be something completely unique that another system isn't doing, you know, and so I think it's just to generate ideas and thought versus modeling after a specific system, because I don't think an ideal system exists, right? Of do exactly what the system does. Every place is so unique in terms of how they're set up and how they came about that there is no kind of exact replication that we would ever recommend, like another state model themselves after. But just to generate different ideas, especially if you've never worked in another state system before, it's hard to imagine and kind of visualize what possibilities are out there.
And one of the reasons I wanted to say a little bit about sentencing guidelines is that's the approach that other states have taken when they're worried about the disparate judicial decisions. We all took the parole single body approach to level out disparity. Sentencing guidelines are the way, the one way that other states have tackled that same issue.
Because there's 32 circuit court judges across the state, and you may get 32 different answers when it comes to setting minimum sentencing, that may invite forum shopping. And so the way that other states have tackled that, as Carl points to, is they've set out these sentencing guidelines through years of overhaul and looking at each individual statute and crime and determining, okay, what is the appropriate level? The other thing to keep in mind is when you talk about guidelines, you're talking about, on the federal side, there are big arguments over what exactly did the defendant do versus not do. It's not like on the state side where, okay, somebody pleads no contest, here's your sentence, right? No, on the federal side, sometimes sentencing can last days. And the pre-sentence report takes on a whole new meaning because you have, like I said, you have big arguments over, okay, what precisely did you do? The factual circumstances of the offense need to be drilled down and they need to be hammered out so that you can then plug into the guidelines at the appropriate level. And that takes a lot of resources. So that's all stuff to think about. Again, the easy analysis is, okay, yeah, parole board, nah, give it to the courts because it's more transparent or because we hear from different people. But I guess I would just ask everybody to think about, what are the law of unintended consequences here? There are a lot of people, I think, in this room that are conceptually in favor of taking it away from the parole board. And I'm not sure I'm not one of them, okay? Because it certainly gives me more leverage in resolving cases. But, there's a lot more that goes into it. And the other thing too is I think there may be some tension if you look at federal case law, there may be some tension with respect to, on the one hand, you have an administrative body like the parole board making value decisions in terms of the nature of the offense and what occurred and what didn't occur. When you have judges making those types of judicial determinations that would affect the minimum sentence, that may, in certain instances, run afoul of federal law. And so that's something that we may need to look at and we may need to
Yeah,
consider.
I want to have a little sidebar with you, Judge, Susan, about that, because to me, I was struck by when you're referring to the right to a jury to determine the minimum punishment or the maximum punishment on factors that are disputed. And there's a long line of cases. Booker is the one that people know.
Aline is the case.
Aline is
the
the Lockridge example.
Yeah, if you're gonna
You're
make
gonna raise the
judicial,
minimum.
Yeah.
When I started looking at Hawaii, I thought, doesn't this violate Aline?
Yeah.
Because the parole board is making a minimum decision.
and the reason it doesn't is only because our intermediate court of appeals has a long line of not even decisions, but summary disposition orders that says it doesn't. That's the only reason why Fred and his group can make nature of the offense decisions that affect your level of punishment. That don't run up, that aren't being made by a jury or admitted to by the defendant, that affect your level of punishment in terms of your minimum sentence, and not run afoul of federal law is simply because our intermediate court of appeals has decided that for whatever reason, that what the parole board does isn't part of quote unquote sentencing, but rather it's a separate function. Whether that's going to hold up if somebody challenges that in federal court, I don't know. But again, when you shift this responsibility over to the judges and you're doing it all in court, what does that entail?
I think the devil's in the details. That's gonna be the problem.
I agree.
It comes down to just that, to be honest.
Yeah, and we would not want to be part of a recommendation that just says, take it away from the paroling authority, we're out, we're going back to the mainland. Because the judge is right, you're right, Tom, the devil's in the details.
One
What
thing
are you
you
gonna
can-
replace that system with,
Yeah.
and how are you gonna get at the same problems you were trying to get at with the current system? How are you gonna ensure transparency, uniformity, consistency, etc.?
Yeah, one thing the ICA did do, which I thought was a good idea, was whenever the parole board deviated from the guidelines, they had to provide a written justification on the minimum notice. And that clarified for HPA their, not just their authority, but if you do deviate, you need to justify it in writing. It can't be capricious and arbitrary. It has to be something spelled out.
And one thing, maybe, I don't know if maybe John and I at the next meeting, you know, we can maybe talk about the line of cases, Apprendi, Aline, Booker, Blakely, all of those cases that would affect what it is that what we have to do here. And how, if we shift this responsibility to the courts, how do we need to craft it so that we're not running afoul of federal law where the courts are now making determinations, what we call nature of offense determinations that raise the minimum level of punishment in such a way that, you know, is supposed to be reserved to a finder of facts such as a jury.
And I will say, Judge, of course, those cases sent huge ripples through state systems and the federal system back when they happened. And created a lot of consternation, but in every place that I've looked at, they fixed the problem by just setting out in statute that or in court rule. The defendant has a right to get to a jury if there's disputed facts that affect the minimum punishment. And, you know, 99 times out of 100, that right is not invoked, there's a plea bargain and no problem. But when there is that desire to get to a jury, there should be the procedure set out and you can do it. So it's an issue, but it's not an end of the world kind of issue, at least the way it's played out in the states.
Well, here, after the minimum term is set, the offender can file a Rule 40 petition if he disagrees, you know, seeking post-conviction relief, if he believes the HPA set the minimum too high, deviated from guidelines, or a whole bunch of stuff. And that happens more than you think.
Sure.
Yeah.
A lot.
And that all comes back to the courts.
Yes, it does. And then the ICA says, HPA, you did okay.
And I'm recognizing the time. I didn't know if.
Well, I want to have a few more comments. I didn't want to interrupt the discussion. It was very good at this time.
Yeah, just real quick, the judge's point is really, really good one, because as a point has been made, I mean, any change, if that's the outcome of, you know, the recommendation that comes from this group, is gonna require an extensive and well thought out framework to make that workable, right? So what I hear here is that should go into, I think, the considerations on how much time and the frequency of our meetings, so that we can get to some of those decisions and move on in an appropriate manner. Because the judge's point, there's things we're going to be able to accomplish, and depending on the decision made, things that will probably require more time to accomplish. That fact shouldn't prevent us from making tough decisions, right? Shouldn't prevent us from making the right decision that we believe is in the best interest of our communities. And by saying that, I don't think this would, what anyone has said is, the fact that it's hard shouldn't mean that we just say, hey, let's just leave it the way it is.
Agreed.
But I think too, to add in, that many people inside, outside, don't realize that there will be, if we make changes, statutory amendments and or possibly constitutional issues, state constitution, because of the separation of powers. And that's been upheld by the Supreme Court on previous suits on sentencing in Hawaii.
Yeah. That's one of those search terms I love to use, is separation of powers and clemency, or separation, because that, if there's any interesting stuff going on, that triggers it.
Yep. Good.
Do you have any final comments from the community online? George, can you show that picture up there?
And while George is doing that, I want to put in a plug for this really nice document that Aaron's group has provided. A really good summary of the way it works and why I recommend it to you all for review. It's a great refresher on what we've talked about today and more.
So one last thing I want to bring up, just because of timing, I thought I could just email out the last two slides that kind of talk about like data to pull, and that way, like, as you all think about it, sleep on it, talk to your team. If you think of data that you're like, yes, we need to look at this, send it our way. The other thing is that CSG is kind of asking about, you know, if there's any people or organizations to meet with, activities to engage in. They're going to be here this whole week. And so if there's anyone in particular or any organization you're thinking, yes, like super important, like just touch base or send an email either way, touch base after this meeting or send an email, but I'll send that out too, just so everybody can take a look. Because I know we kind of ran out of time to talk about that specifically, so I wanted to make sure we included it for you.
And I have written down some of the suggestions for potentially the next meeting in November would be kind of what judges have available to them and consider in terms of sentencing, and what HPA has available to them and what they consider in terms of the minimum sentencing, and providing an overview of that. So I think that's something that I don't know if some of the task force members want to present on kind of those with your individual areas of expertise, or if that's something that you would prefer that we can help gather and present on that, and you can add context and information. Definitely flexible either way, whatever makes the most sense for the task force members. And then some of the judicial sentencing cases that you brought out, Judge. So.
And the unified state question.
And then, yeah, we have the unified state question, as well as the victim question and the victim rights. And then I know at some point, depending on the length of the next meeting, whether or not there's any data that you want us to share or present on as well.
Between now and the next meeting will be a lot of conversation, but we will be transcribing the meeting today, getting some of the main ideas down and trying to help us develop the next agenda. I do know we do want to talk about data. Yeah, Erin, give a little bit of a presentation from her office and others that we're inviting as well. Continue to talk about data throughout the systems in Hawaii that affect our discussion, and we'll make those recommendations online, so we all know the next meeting what we will be prepared to come and discuss. So for first meeting for me, it's very educational, as I am not part of the front system, and so it's very easy for me to be here and be kind of neutral because I don't know what I'm talking about, and I'm just really listening to everything that's being said right now. I'm on a huge learning curve. So I just want to thank you all for being here and taking the time off your busy schedules to add the input. And I really appreciate the aloha that's shared around the table, that we can have these discussions and laugh about it, and just continuing our sharing. So with that being said, we look forward to seeing you in November. Thank you so much.
Thank you.
Thank you.